Deputy Minister, DG, and your delegation. I see chairpersons and CEOs of entities, and our colleagues from the media, and our staff from Parliament and the ministry. Secretary, are we ready to start?
Good morning, Chairperson, and good morning to everybody in the House. Yes, Chair, we can start.
Thanks very much. Let's have the agenda lighted. There is the agenda, honorable members. Opening and welcome, which you have done. Consideration and adoption of the agenda. Apologies. Opening remarks. Briefing by the Department of Human Settlement on the implications of the Concourt ruling. Deliberations. Briefing by the Department of Human Settlement and SHRA. Deliberations, briefing by the Department of Human Settlement and CSOS and PPRA. Deliberations, minutes and closure. Can I get a motion for the adoption? Honorable Ditebe.
Good morning to you, Chair, and everybody, Minister, Deputy Minister, DG, everyone. I move for the adoption of the agenda.
Thank you. Any seconder? For Honorable Frenchman.
I second that, Chairperson.
Thank you very much. This is what will guide us in today's meeting. Can we move to the next item, Secretary? Apologies.
Good morning, Chairperson again, and good morning to Minister DM and the officials from the department. Chairperson, I received 2 apologies. Meki Khakilwe has a bereavement and she is not able to join us today, but I've just sensitized her that she can join virtually if she gets time. And Ms. Dlamini, she has organizational challenges, so she won't be able to attend. Thanks, Chair.
Thanks very much. Are there other apologies that we might have missed? Thank you very much. Okay. I expected an apology, but maybe it will come later. What's the next agenda item?
It's Concourt, Chair.
Or maybe before that. Honorable members, Minister, Deputy Minister, Director General, chairpersons of the department's entities and CEOs, distinguished guests, ladies and gentlemen. I'm told this meeting is live, both on TV, YouTube, and this is to satisfy some of the MK parties so that they are seen that they are working.
But you gave us the wrong venue. That's why I'm not on combat. I'm supposed to be on combat.
Okay. Honorable members, South Africa continues to face significant challenges in securing well-located land for low-income housing. The legacy of apartheid spatial planning rising urban land prices, and persistent administrative barriers continue to push affordable housing developments to the urban periphery. Far from economic opportunities, public transport, and essential services. This entrenches spatial inequality and undermines the government's objective of creating integrated and sustainable human settlements. The recent Constitutional Court judgment in Adonisi and others, Vice Minister for Transport and Public Works, Western Cape, and others, has reaffirmed an important constitutional principle that access to well-located public land is fundamental to the progressive realization of the right to adequate housing and to advancing spatial justice. The court made it clear that public land decisions must contribute to dismantling apartheid spatial patterns rather than reinforcing them. This judgment therefore represents an important milestone in the country's efforts to realize integrated human settlement. More importantly, the judgment raises pointed questions for all spheres of government, namely that are institutions adequately resourced, sufficiently capacitated, and appropriately coordinated to implement these constitutional obligations. The success of this judgment will ultimately depend not only on the legal principles it establishes, but on the ability of national, provincial, and local government to identify, release, service, and develop well-located land for affordable and social housing. This challenge extends beyond the Western Cape. It speaks directly to the performance of the Department of Human Settlement, Honorable Minister, and its public entities, whose effectiveness is central to the delivery of the integrated and sustainable human settlements. The committee remains concerned about governance weaknesses, project implementation delays, financial constraints, and operational challenges that continue to affect several entities within the department, with the beneficiaries and communities being the victims. The Social Housing Regulatory Authority continues to face significant challenges in addressing blocked social housing projects, which delay the delivery and occupation of affordable housing units in strategically located areas. On the positive note, the Community Schemes Ombud Service has made progress in strengthening governance within community schemes, but administrative backlogs and capacity constraints remain. While the Property Practitioners Regulatory Authority has demonstrated improvements in organizational performance, persistent governance shortcomings and information technology challenges continue to affect its ability to regulate the property sector effectively. Taken together, these challenges underscore a broader issue of institutional capability within the human settlement sector. Constitutional rights can only be realized where public institutions possess the capacity, resources, and leadership necessary to translate policy and legislation into tangible outcomes for people. As a committee, our responsibility extends beyond monitoring compliance with legislation. We must satisfy ourselves that the department and its entities are equipped to implement constitutional obligations effectively, utilize public resources responsibly, and accelerate the delivery of well-located, affordable, and sustainable human settlements. Today's engagement, therefore, provides an opportunity not only to assess performance, but also to identify the reforms, partnerships, and interventions necessary to realize the transformative vision articulated by the Constitutional Court and the National Development Plan, Vision 2030. I trust that today's discussions will be constructive, candid, and solutions-orientated as we collectively work towards building more inclusive, equitable, and sustainable human settlements. I just take it for granted, Minister. I know some entities, some councils or board were appointed in 2024, but I just take it for granted that they are all appointed in January 2025. If I count from there, we are almost half year, about 18 months. So we want to know what is it, what legacy are they living, because they are in the middle of their term. They found the organizations in a particular state. What impact have they made to change, to deal with challenges and improve the organizations, rather than focusing on other issues that are not beneficial to the communities and beneficiaries. There's a serious need for social housing. The other day I was talking to the minister and the executive mayor of Polokwane. There are huge developments coming in Polokwane, building of new stadiums, building of hospitals, the expansion of the university, and all this will require accommodation. And it is our role as a sector to make sure that we provide for that. Let me conclude by congratulating Banyana for having won, and I think they are proceeding to the next round, and we wish them luck. We hope they will proceed up to the end of the tournament. I was in Moria over the weekend, Minister. Ke no ka ba profeta ba bolela ka audit opinion. I'm not sure. I'm not sure. They were just murmuring about the audit opinion. I'm not sure what is the issue. I'm also told we are launching the habitat what? I'm told the ED will be arriving in the country not long, and it is my wish, because this committee has been in the forefront with regard to that. It is my wish that they be part of that historic moment. And if they are invited, if we can be advised quickly so that we are able to adjust, because if the information I have is true, the launch will be on the 14th, which clashes with one of our meetings. So if they are invited, I think priority will be given to the launch. Then we can readjust our program. But we'll hear from the minister, because they can only be invited by the minister. Thanks very much. You are all welcome. Let's move to the next item, and we allow the minister to give us her remarks before we get the presentation. Thank you, Honorable Minister.
Thank you very much, Honorable Chair. Let me pass greetings to the Deputy Minister, Metandi Mahambehlala, the team led by the Director General. From the administration side, DG himself, DDGs. We are accompanied also, Chair, as per our invitation. Joining us is the chairperson of CISOS, Mebusi Nzo, chairperson, and the team from PPRA, Me Quindi Kungubele, and their supporting team. Chair, I will explain at the time when we are ready to deal with the presentation that relates to entities. We were supposed to have SHRA, as we have correctly indicated, but I'll dwell into the introductory remarks as we get into that item. Let me also greet honorable members and say you look very refreshed. I think Honorable Paul, the time for, it was very helpful. Even myself, thank you very much. Chair, we are appreciative as we always are, and let me pass my really words of, I'm saying I'm sorry to you, Chair, and the team that was trying to fly timelessly yesterday. And their trip ended up becoming 8 hours long. I took a leap of faith and chose this morning. Chair, the implications of the Concourt judgment, I think we need to firstly look into what does our constitution promise. Section 26 affirms that everyone has a right to access to adequate housing. Firstly, it then requires all of us jointly in the state and the separate levels of powers within available resources to take responsible legislative and other measures towards the progressive realization of that right. And this right is not necessarily in isolation to providing a box of a house and walking away. It needs to address spatial injustice, allocation. It needs to address integrated planning jointly with other departments. We also need to address with that economic emancipation of all South Africans by choosing sites that are going to be able to allow our people to use and access mode of transport easily, save money and on costs that is inclusionary in part of their day-to-day lives. They shouldn't spend the money on traveling half of what their earnings are, but they also be able to be accommodated or housed in areas where utilities and communities that are created are able to create a space where our communities and people work, live, and play. We are appreciative that we face a deep housing need. It is entrenched mostly in the Western Cape by the spatial inequalities. There's been quite a number of differences, which sadly all of them get to be resolved at the Constitutional Court level. And I think it's time for us, Chair, to ponder jointly as ourselves, provincial government, and ourselves in the portfolio, on how best could we deal with the issue that seems to address spatial inequality, such that people of all walks of life can be able to access convenience. People could have a choice of where they want to reside, and the responsibility of government should therefore be to bring aid into that, avail land packages for various typologies of the basket that human settlements provides countrywide. Sadly, it has not been the case. And the record legally speaks for itself. On the invitation of MEC Simas, last week I was here with, in the infrastructure summit, and fundamental to what I've raised is this very same issue, that it is high time that we go back into our IGR framework and relate better with the province, and the province to relate better with the city of Cape Town in this particular instance, to be able to resolve the issues who, unfortunately, people who are impacted are not necessarily sitting on the table, but they are observers when the right and a need for housing and accommodation properly for them is neglected. So we need viable alternatives. Chair, I was very grateful on our discussion and our engagement that at the portfolio we need to invite also the Western Cape Department of Human Settlement. So we are held accountable jointly. In almost all the cases, the department has either opted to abide, to oppose including the latest sale of land, which there was a pastor who had put an offer of about 100. We objected in writing to the city of Cape Town, and we requested, can we have a discussion and see how we could amenably resolve such issues? And rude responses like, we don't report to you, you have got no say in what we want to do and how we want to do it, is how the matters are being resolved and responded to. But I think we need to take a deep dive really into the issues of the land parcels in the city of Cape Town, the priority that needs to be given to the historically disadvantaged. But we also need to take the challenge which I've raised with our HDA in a formal meeting with their board chair, accompanied by the DG, that we also need to utilize all the parcels that we have, which mostly are convenient and could be able to assist us in social housing. Chair and honorable members, we also need to face the difficult question. It is just not affordable to live in Cape Town. It's a question we need to look into. We need to find mechanism on how do we increase on the affordable rental stock, so SHRA becomes a very credible, jointly with HDA, entities that ourselves we can be able to utilize to make sure that we cover the gap. But we all need to understand that Section 26 of the Constitution mandates, including the city and the province, to make sure that housing is available to each and every. It's the responsibility of the state. We cannot pass that to anybody else. Now it is even difficult, even for the employed, to stay in the city. It's difficult for the poor to be allocated convenient spaces. So the fundamental question is, who is Cape Town designed for? It's designed for who? And who must live where and why? And I think that question is of importance. But Chair, I'm glad that we have this opportunity, and I'm going to, with your permission, request the DG to take us through the presentation so that we can have an informed decision. But I would want to emphasize that even on this case, as the DG will indicate, the department was on the side of those whom we believe are more vulnerable in comparison to a state that can be powerful. And we've seen how local government in the apartheid era used to be utilized to relocate and enforce a dislocation of people. But we did not act in that way. We acted not only firstly by opting to go to court, but to say we have got the intergovernmental relation framework that can compel all of us as the state to even find a suitable mediator to test on the cases as to whether they are valid or not. And DG will explain the response, which also just sort of said, this matter does not belong there. We don't see how you see it. We don't view how you view it. And the sale continued. Now we are at the level where we are sitting with the outcome from the Constitutional Court. And I think your guidance in how we view the issues as we will deliberate will also be sought in how best do we resolve this matter. Thank you very much, Honorable Chair. And with your permission, we can hand over to administration.
Let me request you to comment on the two, the prophecy and the UN habitat.
Okay, Chair. Hey, do I qualify to comment on the prophecy, Chair? But let me start with the official confirmation, Chair, supported by DECO, of the ED visiting South Africa now in the month of August. Congratulate also TTG Ngongo, who has been leading the program with UN Habitat, even prior my arrival, to say, yes, we are seeing now the official launch and the official opening of our office in South Africa. Quite a lot of work has been done, even in terms of beginning beyond the MOUs, the recruitment processes, the strategies which have already been outlined. Chair will accede to the call and make sure that we share DDG and DG immediately at the end of this portfolio, official invitations to honorable members, but we would really like you to come and observe on this important milestone that human settlement has reached. And for us, what is fundamental is not only the launch and the visit. I think it's us putting a framework that will be able to advance the interests of South Africans, in particular to key identified areas which assist us, for example, in dealing with mitigation strategies for climate change, in dealing with proper integrated planning, which is one issue which we are indirectly discussing as in the court outcome, which will also allow us into packages of how best do we plow back human settlement into our communities. We are learning from quite a number of countries who are also signatories to the United UN Habitat, and policies like rent to buy is what the department is reviewing and learning from other countries that are already advanced. Culturally, South Africans, contrary to London, New York, they prefer to own. They may not have means at the beginning of owning. So a system that you are running needs to accommodate them as they still rent, but as they progress in life, be able to be given a right to own the space which they would have been calling a family or a home for quite some time. Ta tabeng e kgolo ya Sione, Ngwana Bishop, I think the vision is correct. We came here, we committed ourselves, honorable members, that in the past audit, we were almost close to a clean audit. To be exact, we had 2 matters, in fact, 1 matter of emphasis. We actually were smelling the clean audit even in the past cycle, but it escaped us, but not this time around. We went back into our action plan as we presented it to this committee. We lived by it, line by line. And for the first time, we've achieved a clean audit after a number of years. And let me thank the team led by the DG. CFO is not here, but DDG 2C also a very strong branch at corporate services, where we also had quite a bit of challenges in relation to the AG not happy with the management of consequences in relation to upper level or echelon of the department, which was others, chief directors and DDGs. And they've been able to really put their foot forward, and quite a number of those cases have already been closed, and the others have been, we've been able to show progress on what we have. So, Chair, your team has led us to a clean audit, and we appreciate that. Thank you very much.
Now we congratulate you for that, and we wish Mudumo Molo Atavasun Adiro really sustain, because it is in our interest. It gives confidence to our communities that you are really taking care of their taxes as taxpayers. We just need to make sure that whilst we achieve clean audit, we also make sure that they receive the services they so deserve. But that is a milestone, and we really congratulate you for that. Minister, under your leadership and the leadership of the DG. Thanks very much. I know we're still going to discuss that. I was just worried about this prophecy, what it means. Now I'm fine. Okay, let's allow the DG to present. Maybe I must say it up front that Western Cape Department of Human Settlement was invited. They responded to us that the matter is still sub judice. Some will say sub judice, some will say sub judice. They still have to go back to court in 3 months' time to indicate to the court how they are going to do it. So they felt, in their view, according to the letter, in their view, it is not an opportune time to brief the public, because today, as they will be briefing the committee, they will be briefing the public also. So, but that's what it is. Let's allow the DG to...
Before that, please, if you don't mind. Chair, I think that is very unacceptable. I think even somebody who has year one understanding of the law understands that this is the apex court, the constitutional court, and there's a reason why our constitutional architecture was designed that way. The counter-majoritarian principle is deeply embedded in it, and therefore above it, there is no other court that can adjudicate the matter. My understanding is that they simply have to comply, and therefore to invoke that as an excuse is very flimsy and disrespectful to this committee. Thank you.
Thank you very much. You said law 101. DM.
No, thank you very much, Chair. Greetings to the Minister, the DG, and his team, honorable members, the entities led by their chairpersons. I just want to help you, Chair, so that you disabuse yourself moving forward. There is no Department of Human Settlements in the Western Cape. It's a branch. They have what they call Department of Infrastructure and VAT and VAT. Human Settlements, it's a branch. It's like those branches of the DG there in the department. So which is why we will always have challenges. So it's a homework for the portfolio committee, so that if you want to invite them and engage them on why do we have branches of the DG in the Provincial Department of Infrastructure, then it's your call. So I thought I should try and bring that information to you. Thank you.
Thanks very much. But the feeling is that the apology is not acceptable, and we'll take it forward from there. Thanks for the information, DM. As we move forward, we'll take that into consideration. Thanks, DG.
Good morning, Chairperson. Good morning to the Honorable Minister and Deputy Minister, to the Honorable members of the Portfolio Committee, and my colleagues in the department, as well as in Parliament, as well as other members of the public and the media. Chairperson, our understanding of the matter is much, much closer to what Honorable Ditabe points out to, with just a small proviso. Indeed, the judgment itself would not change. The Constitutional Court is the apex court, and therefore there would be no room for appeal or anything. The only legal available mechanism is to ask the Constitutional Court itself for a self-review, to review itself. But the provincial government, even its own letter, does not suggest that that's the route they are taking. They are suggesting that they are taking the route on how best to implement the decision, and they are saying they are seeking legal advice on the provisions of that judgment in order to comply and go back to court. They indeed go on to outline the processes in their letter of how parties would be expected to file and to comment on the report that the court requires, and thereafter what likely process the court would take. So given that, we too would play very shy from talking about the report itself or possibility of such a report and its contents and whatever. We'll await for such to be filed with the court, and would only comment before the court about that report as we see it, being a party to the matter. We will, however, brief the committee about what the judgments say. That part we do not believe is sub judice at all. We think that it is a fait accompli. The court has already pronounced its position, made a ruling, and also made an order. We will explain to the committee what that order say, what the judgment was. We'll also look at, most importantly, the rationales decidendi for this decision, and also touch upon the statements by the judges made in passing, or what they call the obiter ductum. We will capture those, and because the two give the spirit of why the court arrived at a decision it did. And I think that is what we will confine ourselves to. But we do hasten to indicate that, yes, we are aware that there would be a report that the order compels the provincial government to file with the court, and that should show progress on the implementation of what the court is desirous to see happening. And we will comment on the efficacy or less thereof once it is before the courts, and we'll comment there, will not comment anywhere else and in the public. So that's the refrain, Chair. I would ask DDG, Acting DDG Tusi and Mr. Paul Masamola to give the presentation. But I wanted to give that clarity so that we can distinguish where we are, so that we are also not accused of transgressing the court processes. But we have checked with ourselves and have satisfied ourselves that to the extent that our presentation covers, there would be no impinging or undermining the authority of the court. Thank you very much, Chair. With your permission, I'll hand over to the two of them.
Thank you, DG. Good morning, Minister. Good morning, Deputy Minister, Chairperson, and members of the Portfolio Committee, and the colleagues from the entities and the department. Chair, I'm going to request Mr. Masemola to take the committee through the presentation. And yeah, the presentation is already on the screen. Please proceed.
Thank you. Okay, let me mute. Good morning, Chairperson, Minister, DM, members of the committee, DG, chairpersons of entities, and colleagues. The purpose, or rather the presentation outline It's a purpose, summary, discussion, constitutional court judgment, implications for the human settlement sector, conclusion and recommendations. The purpose of this presentation is to request the Portfolio Committee on Human Settlement to note the judgment of Tafelberg matter and implications of the judgment to the human settlement sector. In summary, which will also give a form of a background, the property was under the control of Western Cape Department of Education and utilized as a school since 1989. The school was closed in June 2010, and since then the property has been secured with barbed wire and remained unused for more than 16 years. The property is registered and owned by the Western Cape Provincial Department of Provincial Government, which commenced steps in August 2010 to determine the most suitable way to utilize this derelict property. The land was earmarked as a restructuring zone in Sea Point because the city had presented that, and together with SHRA, that it will be CBD and the surrounding areas. So it would have included Sea Point. In 2013, the Department of Human Settlement advised the Western Cape Provincial Government that they have an interest in the property for use as the development of integrated and sustainable human settlement, especially for social housing. The sale the provincial government informed the DHS that it does not have an obligation to consult with DHS when selling its property. And I think that's what the Honorable Minister was indicating, that the department would have engaged the provincial department to try and find a way that before selling the property, they should engage with the national department to make sure that, as the department had indicated, that it does have an interest in using the property for social housing. The property was sold to a Jewish day school in January 2016 for an amount of 135 million. And the department, together with social groups such as Ndifunungwazi, had successfully opposed the sale. And on March 2017, the Minister of Human Settlements informed the provincial government of her intention to refer the dispute over the lack of consultation in terms of Intergovernmental Relations Framework Act. And that's the act that provides, in terms of Section 41 of the Constitution, that says that various spheres of government should work together to try to resolve their issues where they have differences or disputes. The provincial government nevertheless continued to be adamant that the act is not applicable to in the circumstances. And as I've indicated, the sale has been then challenged on two fronts in separate applications before the court. And the first application was for inter alia, the review of the sale of the Tafelberg site, and it was launched on the 5th of May 2017 by Adonis and 5 others. They were citing Minister of Transport and Public Works, Western Cape, as the first respondent, together with 11 other respondents, and that included the day school and the City of Cape Town, together with the Minister of Human Settlement, meaning the National Minister, and the Social Housing Regulatory Authority as the respondents. But on the 11th of July 2017, the National Minister of Human Settlement effectively joined the litigation by issuing her own application for declaratory and other relief. And she then joined the National Department of Human Settlements and SHRA as the third applicant. Included amongst the respondent in the National Minister's application were the first respondent was the Premier, the MEC of Transport and Public Works, and the City of Cape Town, together with the day school. The National Minister's case is founded, or was founded firstly in Chapter 3 of the Constitution and the legislation promulgated pursuant thereto, meaning the provision of the Intergovernmental Relations Framework Act. And the National Minister similarly attacked the validity of the Western Cape Land Administration Act, the regulations, and further relied on non-compliance by the province with Government Immovable Assets Management Act in calling for the review of and setting aside of the sale of Tafelberg property to the school. On that basis, the minister asked, amongst others, an order in terms of the revised draft handed to court at the conclusion of the hearing, that it must declare that the Western Cape provincial government failure to inform the national government, represented by the first and second applicants, the Premier, the MEC, of its intention to dispose Tafelberg properties at Sea Point, and prior to doing so, to consult and engage with it in this regard, constitute a contravention of Western Cape provincial government's obligations in terms of Chapter 3 of the Constitution and the Intergovernmental Relations Act. On the 31st of August 2020, the High Court granted the following orders that in the Ndifunukwazi case, that the High Court declared that the province and the city have the following constitutional obligations: to take reasonable and other measures within their available resources to foster conditions which enable citizens to gain access to land on an equitable basis in accordance with Section 25, subsection 1 of the Constitution, and in accordance with Section 26, subsection 2 of the Constitution, to reasonable legislative and other measures within their available resources to achieve the progressive realization of the right of citizens to have access to adequate housing as contemplated in Section 26, subsection 1 of the Constitution. The Western Cape provincial government and the city appealed, and the Supreme Court of Appeal upheld the appeal against the High Court order, and hence the National Minister and the Ndifunukwazi had to apply for leave to the Constitutional Court, which was granted, and it had now taken us to where we are today. And then at the Constitutional Court, it then held as follows on the Constitutional Court judgment: the failure of the provincial government of Western Cape to inform and consult with National Minister of Human Settlement regarding its intention to dispose of Tafelberg property was a contravention of the province's obligation to cooperative governance in terms of the Constitution and Intergovernmental Relations Framework Act. Regulation 4, Sub-Regulation 6, and the provisions of Regulations 4, Sub-Regulations 1 of the regulations made under Section 10 of the Western Cape Land Administrative Act are unconstitutional and invalid, in that, contrary to Section 3 of the Act, the impugned regulations provide for public participation to take place only after the disposal contract has been concluded, And this means that how it was crafted, it was that consultation can be done even after the property would have been sold, and the court would have indicated that it is not helpful, that kind of engagement, because already the property would have been sold, and to renegade on it, it might be difficult. And when you make an input, you do not know how it will affect or shape the ultimate decision, because the cabinet would have, of the Western Cape, had already concluded the agreement with the school. However, this declaration is suspended for 12 months for the date of this judgment in order to allow the defects to be remedied. So the provincial government would then have to amend the regulations to make sure that they are in compliance with the constitution. The implications for the human settlement sector. The constitutional rights of access to land and adequate housing must be considered in light of the racial and class-aligned pattern of segregated residential settlements and socio-economic exclusion in the landscape of urban areas that still derives from apartheid. All spheres of government are the custodians holding public land on behalf of the people. As such, has an obligation to promote equitable access to cities for all their residents, to promote inclusive development. Social and affordable housing development should not only be accessible at the urban periphery, otherwise those who depend on it will face significant structural barriers to accessing the city's economic opportunities, healthcare, education, and concentration of cultural and political life. The right to adequate housing, as contained in Section 26 of the Constitution, entails that the adequacy of housing provision includes not just the provision of a shelter, but also considerations of its adequate location, meaning whether the housing is situated in an area that are well located with respect to urban opportunities, employment, services, and social amenities. The right to adequate housing, as contained in Section 26 of the Constitution, entails that the powers allocated to 3 spheres of government sometimes overlap. However, laws within each sphere can serve different purposes for the level of government charged with a responsibility for administering them. Therefore, compliance with Section 41 of the Constitution is necessary, since it obliges the 3 spheres to cooperate with one another in mutual trust and good faith, and to coordinate their actions with one another. And this is the section that I spoke about, that regarding the intergovernmental relations. The Constitutional Court provided that the Government Immovable Assets Management Act establishes a standardized framework for managing state-owned immovable assets to align them with service delivery objectives and promote efficient government. It applies to national and provincial departments, focusing on accountability, cost optimization, and socio-economic priorities. Section 5 of GEMA sets out the principles of immovable assets management regarding the use, acquisition, and disposal of immovable assets. The management of state assets must also be considered in light of the transformative objectives of the advancement of socio-economic rights and land reform, and this necessarily include cooperation with other spheres of government. The provisions relating to the disposal of state land are instructive in nature and accordingly must be complied with. This means that when the provincial government disposes the provincial land, it must comply with GEMA in order to progressively realize the nation's socio-economic objectives. This necessarily includes cooperation with other spheres, as I've indicated earlier, that, and the minister would also indicated earlier that it is important to work together to ensure that we are able to fulfill the mandate of human settlements. It is necessary to undertake a meaningful engagement or consultation with communities and other spheres of government when disposing land or properties, especially when the other spheres shows an interest in such properties. In instances where the different spheres of government disagrees and are unable to resolve the matter, the Intergovernmental Relations Act should be a guiding tool to resolve those challenges. In conclusion, the policies and the programs of human settlements must consider location as one of the most important factors. The state should prioritize strategic use of public land as it is an important part of the meaningful provision of affordable housing within the cities. The National Department, which is an applicant in the matter, it will continue to ensure that it plays a role of supporting the province, but also to make sure that timeously they respond to the reports that they are expected to submit to court within 3 months. And the recommendation is that we recommend that the Portfolio Committee on Human Settlements to note the judgment at Tafelberg matter and the implications of the judgment to the human settlement. Thank you very much.
Thank you very much for the presentation. There is a presentation, honorable members. I don't know whether there are questions for clarity, because according to the DG and the letter from Western Cape, they still need to submit reports to the court on the plans, because amongst others we requested plans on the implementation of the court order, but they still have to submit to the court first. Anything? Honorable Ditebe, Honorable Magagula, Honorable Gamede, Honorable Poole, in that order.
Thank you very much, Chairperson. First of all, I think it is proper to congratulate all the parties that went to court to litigate, the non-state actors like Ndifunukwazi, and indeed our very own minister, with emphasis being placed on what the DM said earlier. It is for me very important, Chairperson, that, excuse me, we look carefully at the principles underpinning cooperative government and intergovernmental relations as enshrined in our constitution at section 41. And when one looks at the judgment, Chairperson, 41 sub 1 paragraphs A, I think up to D, and I'll read those out just for purposes of jogging our memories. And it reads, principles of cooperative government and international intergovernmental relations. All spheres of government and all organs of state within each sphere must, A, preserve the peace, national unity, and the indivisibility of the Republic. Very important. Secure the well-being of the people of the Republic. The well-being of the people of the Republic. And without exception, the well-being of the people of the Republic extends to the people of the Western Cape. Provide effective, transparent, accountable, and coherent government for the Republic as a whole. In other words, not for any other sphere of government in a particular municipality or province to do as it pleases and totally disregard the letter and spirit of our constitution. Respect the constitutional status, institutions, powers and functions of government in other spheres, etc. But these that I've read, Chairperson, especially from A up to D, in my view, coincide with the correct judgment of the Constitutional Court, because we have a history in this country of colonialism, of apartheid. And while people would like to simply assume a kumbaya approach that, you know, apartheid in its formal state is gone and that its legacy no longer matters, that matters a lot. Race, class, gender, the history, all of that. We can, in the past, we've talked about the waterfront and its ugly history, and the fact that the people of, even people of this area, there's a security personnel at every point. And it's all because of the interface between capitalism, apartheid, colonialism that we find this part of our country in the state it is in. Therefore, I think it is for us as the ANC important that we underscore the fact that we agree with this because we want to secure the well-being of the people of the Republic and indeed agree with the Constitution as to the indivisibility of the Republic. There is no one who simply on the basis of a particular party governing a particular territory of our country, and that is all well and good in terms of the very Constitution, Section 19, freedom of political association, freedom of political activity, etc. That is okay, but that cannot be used to undermine the fundamental rights and the democratic values and the ideal of social justice. It's very important that we underscore the fact that in the very preamble of this Constitution, fundamental human rights, democratic values, social justice. You cannot read this Constitution while disregarding that as a prelude to anything from the founding provisions of this very Constitution up to the very end of it. And I'm afraid that, you know, there are people who would like to use this very Constitution to undermine transformation. And that's what I'd like to put across, Chairperson. So whatever people invoke as a subterfuge, as an excuse to not do what is right, to not appear before this committee, that must be condemned. Because you will know, even with the George matter, the very same excuse was invoked, you know, sub judice, this and that, hiding behind all the legalities, you know, stalling and stonewalling. That is unacceptable. Thank you very much.
Thank you, Chairperson. And good morning, Chair, and the House at large. Chair, I think some of the effects have been covered by Member Ditebe, but I also want to raise the issue of the Western Cape not being in the House while being invited. That maybe if they were here, they would see they will raise their challenge in terms of challenging the court order, and they would be advised as to which route they have to take, and also maybe they will tell us whom are they standing for if they're not standing for the people, because these are the people who have raised the issue and who have taken them to court, and they've won the court. But unfortunately, they're not here. There's nothing we can do except to say that we are noting the outcome, and I think we also agree with the outcome. Thank you, Chair.
Thank you so much, Honorable Chairperson, and thanks for the presentation. Greetings to everyone in the house. Ntate Masamola, thanks for a comprehensive presentation. Let me say this, Chairperson. Let me quickly go to slide 9 on the Constitutional Court's ruling, slide 9 and slide 12. Yes, it actually does really intellectual work, tying spatial justice to procedural obligations under Government Immovable Asset Management Act and also the Intergovernmental Relations Framework Act. Yet the presentation's own ask slide 3 and 14 is limited to the committee simply not noting the judgment. For a ruling with the weight described in slide 10 and 12, reversing patterns of apartheid era, special exclusion, a note only recommendation feels disproportionately thin. That's my comment, Chairperson. My question, Honorable Chair, slide 6.3 tasked the National Department with supporting timely responses to reports from the Western Cape Provincial Government and City of Cape Town. But what concrete mechanisms and timeline enforces this, given that slide 5.6 2.10 already shows the province has a track record of contesting Intergovernmental Relations Framework Act. Chairperson, just a take home, especially for our legal head, it will be prudent to strengthen slide 14 beyond noting to include a request that the department report back to the committee within a defined period, like 2 quarters, on how the 12-month suspended declaration on the Western Cape Land Administration Act regulations, looking at slide 9, is being remedied. So the committee retains oversight through the compliance rather than losing sight of the matter after the single briefings. Chairperson, thank you very much.
Thank you. Honorable Poon.
Good morning, Chair. Good morning, Minister, and good morning, DM. Good morning, DG and Department, and honorable members. Chair, if I understand the DG correctly, making his input is that Western Cape exactly do what accountable government must do. Seek clarity how to comply to the outcome of a judgment. Where others rather apply to court for urgent interdicts to avoid accountability. The presentation concludes by outlining the broader implications of the judgment for the human settlement sector. It emphasizes that the judgment reinforces the need for all spheres of government to cooperate when disposing of strategically located public land, prioritize well-located land for affordable and social housing, and ensure that land disposal decisions support constitutional objectives relating to the spatial transformation, equitable access to land, and the progressive realization of the right to adequate housing. Now, 2 questions. Beyond noting the judgment, what concrete national policy or legislative changes will the department introduce to ensure that all provinces comply with the Constitutional Court's requirements before disposing of strategically located public land? 2, the Constitutional Court emphasized meaningful intergovernmental consultation. What formal mechanisms will now ensure that disputes between national, provincial, and local governments are resolved before valuable public land is disposed of, rather than through land court proceedings? Thank you, Chair.
Thank you very much. Lastly, Honorable Abad, are you fine?
Thank you, Chair. Sorry about that. Good morning, Chair. Good morning to our Minister, Deputy Minister, DG, DG's team, all chairs, and our support staff. Thank you for the presentation. We're back here with regards to the land issue. And I know that we're trying to get away from the rest of the country, but it is a problem in the whole country. But Western Cape seems to be the biggest problem. And thank you, Minister, for acknowledging that. And I don't want it to just be said here and then we don't do anything about it. There's been so many court cases and we've come to some conclusion, but then it ends there and nothing happens. So what I'm saying is, can we just make sure that this goes forward? I don't have any questions because my questions have been answered by you before we even started. And everything that you said, let's just make sure that we go through that. DM, thank you for clarifying that the Western Cape does not have a human settlements department and that they are a branch, because we all know when it comes to the Western Cape, they basically a law above themselves. And that's not fair, because I myself cannot afford property in the Western Cape. And we all want property here. We all want to live in the center of Cape Town. We don't want to be living in Pelican Park. We don't want to be living in Laboria or the Cape Flats. We all want to live here. It must be convenient. Now, I'm talking about this because of a holiday apartment that I'm looking at. What happens to the people that work here? This is their daily bread. But it took me almost 2 hours to come to Parliament this morning. I left home at 7 o'clock and I got here at 8:45 this morning. It's not fair. And I have my own transport. What happens to the people that don't have transport? And these are the things that we need to start looking at, because this affects people's daily lives. So I just have a few comments. The Tafelberg case exposes how this GNU government and the DA-run city of the Western Cape continues to treat public land as a commodity for sale instead of constitutional asset that should be used to restore dignity, spatial justice, and equitable access to housing. The judgment is a stark reminder that failures in cooperative governance and consultation have delayed housing delivery, while thousands of South Africans continue to live in informal settlements and on waiting lists. Constitutional rights mean very little if they are not translated into action. South Africans do not need more court judgments. They need homes built on well-located land that restores their dignity and humanity. And this is what human settlements is all about. And Minister, you say that often. It's human settlement, so it's human dignity. And that is what we need to bring back to our people. We cannot just be saying it every time we sit together, that we need to bring back humanity and dignity to the people of South Africa, and it ends there. My recommendations is the department must conduct a national audit of all strategically located state-owned land to identify properties that can immediately be prioritized for social and affordable housing in line with the Constitutional Court judgment. And this is where we're going to the broader section of throughout the country and not just the Western Cape. A mandatory intergovernmental consultation framework should be introduced before any public land is sold or transferred, with clear accountability measures for officials who fail to comply with constitutional and legislative obligations. And I propose that we should ask for quarterly progress reports on how this judgment, specifically the Tafelberg one now, is being implemented, including the release of well-located public land for human settlements and the achievement of measurable outcomes that restore dignity and humanity of South Africans in need of housing. Thank you, Chair.
Thank you very much. Minister, those in the main, there were comments, but there are few questions from members. Thank you.
Thank you very much, Honorable Chair and Honorable Members, for the comments and questions. Chair, I'm just going to be brief because I'm hopeful at the response from the province that jointly as the portfolio will have to come back really and give a fairer explanation to the portfolio. I think it is just unacceptable that we are here this morning and talking to ourselves. That's the first part that I think I need to note. We may want, yes, as a department to enforce on what we could be doing beyond the presentation and the noting, as referred to in slide 3 and 14, and come back to the portfolio on measures. But I just want to deal with the issues that Honorable Poole is raising, because I also think they need a political determination and intention from the Democratic Alliance to deal with the issues appropriately. And let's call what it is. You know, there is no any other province that has a case that has been registered refusing government to utilize land, not only for human settlement, for any other interest of society and communities. Could it be an SEZ for economic development? Could it be any other thing that government will need land for? There is a standing cabinet resolution that enforces us all to the IGR table, but also at the availability of land, building, or any other property that is owned by the state that you as the end user needs to circulate first and verify if any of the state apparatus need that building for any form. And it was in that spirit that the minister raised the issue. If you go to slide 3 and look at firstly 2.5, actually in slide 2, that the department was advised officially in writing by the minister that we have an interest as human settlement for the use of the development, and it was very clear that it's for social housing. Before 2.9 come in, so in 2013 we declared the need. In 2017, it was only then that we felt the dispute need to be referred to IGR. So the department honored government policy. So there's no crisis here. Somebody created a crisis that needed us to go to the Constitutional Court. And 2.10 tells you that the province was adamant and even refused to come to the table. You see, IGR does not mean that what I propose and what I put as a motivation is a given or a guaranteed for any of the parties. But at least it provides a table for all of us to live by. Come here, convince me, fail to convince me, state your reasons, and we agree that we are unable to find each other. So, to respond, for example, even in this recent example that I have made, we see an advert on the newspaper. The sale of the building has not gone through the process that I'm talking about. Fine, granted. We write to the city of Cape Town. We say we have got reservations on the sale of this land. Chair, I can copy you the response. So there is nothing that IGR is not being followed, and what mechanism should we look for? People just have to follow the Constitution, which mandates all of us to do everything in the public interest. But it also mandates us further to undo the spatial injustice and make sure that we prioritize the historically disadvantaged. If that's not our intention, it will show. Even the Apex Court will see the flow of how the issues have been dealt with. So I don't think there's any policy new that we need. Maybe we need enforcement. Maybe we need enforcement, but I don't see this discussion of what mechanisms or whatever that we are going to do, because we are following mechanisms that are outlined even in the Constitution itself that mandates us into a IGR. There's quite a lot that is amiss that we need to discuss and make sure that we come into an agreement. I was hopeful, Chair, that this process will give us a fairer discussion. Honorable members will then be able to guide. With the partner, the other partner not present, it limits the discussion. And I think the starting point actually should be more about them coming into the table as well, and we discuss the matter. Refer it back to IGR. The province can't say, even in a court paper, to say, we will deal with discussions after we have sold the building. What type of discussion is that when the business, the land has been sold to somebody else? You are buying it on your own terms and out of your own interest. We have even policy guidelines on how our provinces need to purchase land, because we want to minus the key cost driver in utilizing the limited resources that we have to build and accommodate more people. You need to be able to showcase to us, in the area where you want to buy, isn't there government land that is owned that we could access for free, so that we maximize on what we have, either putting services and putting heads, a roof over the heads of the people, versus the purchase of land. All other provinces follow that as well. But in other provinces, you just see an advert without any consultation, and the response gets to be rude. For me, that's the part that I think maybe there could be a misunderstanding in how I interpret other things, but being humble is the best thing you can ever do, even when you are engaging an opponent. The rudeness is what kills me in how we are able or unable to deal with these issues. Chair, I accept all the comments, but I can't speak to a party that is not here. I can't speak to a party that does not come to my table as well, because I don't have any other avenue besides referring to an IGR process. And I'm indicating here to you, honorable members, that it was referred, and the IGR invitation was not honored, and a dispute was declared, and that dispute was not respected as well. So what else will we be able to do, except, yes, the court outcome, which we ultimately then joined when IGR is not being respected. The only resource we have is the outcome of the court of law, and I'm hopeful that jointly with the province, a commitment I can make, we'll engage them. Chair, we'll seek a meeting with them, we'll seek on coming back to you as a portfolio with a clear program that outlines how are we going to solve this. If that also does not work, I'll come back to you and tell you my endeavors. If they failed, they would have failed, and maybe we could find another way forward. But for us to come here and behave as if there is a crisis that cannot be solved by the current prescripts that we have, I think we're not being honest, because other provinces are using the very same applicable policies and regulations. They give tons and tons of land, Lufereng, anywhere else you could imagine, for government purpose. We had a challenge on TEAs in the city of eThekwini, you all know. A relief we got from Transnet. They wanted to dispose of their building, which they were using as a training college, and we said, we want it because we want to minus the money that we are spending on putting people in bed and breakfast facilities, because floods are a constant reality in KwaZulu-Natal. And we're able to work in an amicable solution, and buildings exchange hands from one government entity to the other. Currently, KwaZulu-Natal is renovating almost at the end, because the building was a bit old and derelict. But it's far much better They had an option of just going without following this government process, but they did. So who else is not supposed to follow it? I think that's what we need to ask ourselves. What are these fundamental differences and difficulties that others experience and others do not? If we don't ask those questions, well, we will not be solving any problem. We can come here and discuss it again and again, but issues will not be solved. Chair, I'm not sure if I was helpful, but we'll come back with our attempt again to engage both the City of Cape Town and the Western Cape Provincial Government on this matter and report back to the portfolio on the progress that we would have made. Thank you.
Thanks very much, Minister. I think let's leave it at that as part of way forward. Our office will continue to engage with the Office of the Minister because this is in the interest of our people to know how are they going to implement it. Honorable Gamete, do you want to say something?
Thank you very much, Chairperson. I think it's important for me to raise this. Honorable Minister, I think you can see what your partner, or should I say your side chick, is doing to you. It's very much abusive. But it's so hurtful when they try to do this to us. It's a disrespect for a province not to honor this meeting. They are taking us for granted. There is nothing in what they are saying. The Concourt has issued their ruling, and what they are doing, we do not take it lightly as MKP. I wanted to put that on record, Honorable Chairperson.
Thank you. Honorable Ditebe.
Chairperson, I think it's also important to note that this is a very disingenuous deployment of lawfare. It's a neoliberal ideological onslaught against our constitutional democracy and our people by this party that forever wants to put up a facade of loyalty to the Constitution. As a matter of fact, even when it comes to equality, they are leaning more to formal rather than substantive equality that the Constitution requires. And I think all of that is laid bare today, both in their interventions in this particular meeting through their representative and their conspicuous absence from this meeting. Thank you very much.
Thank you. But I was not aware that is the minister's side chick. Okay, let's go to the next item, which is a presentation by the National Department of Human Settlements, together with SHRA, on the implementation plan of the blocked projects. Minister?
Thank you very much, Chair and honorable members once more. Honorable Chair, SHRA is not in attendance. And I'll briefly explain from the meeting where they were withdrawn in front of honorable members and the presentation. It came late, but I'd given it a go-ahead, but it was changed in the morning. I committed that I will have a meeting with SHRA. I will try to assist, and I did that. We had a sit down. Besides the issue of block projects, I raised quite a bit of issues that they were unable to comply with. Their quota report submission and all that, which are standard as per the shareholder compact that we need to be able to deal with in the memorandum of incorporation. Our meeting, Chair, to be precise, was on the 9th of June. And that is why I requested a postponement if the chair came through to the department in a request that can the portfolio now sit and receive a presentation on the 24th of June. To allow further, because I met the entire board, SHRA to go and have its own presentation. And fast forward, Chair, to correctly so an invitation for today was granted or was submitted, which we subsequently on the very same day forwarded it to SHRA for their presentation. Our standard protocol to allow myself, the DG Ngongo and the team DG, before okaying a presentation that comes to you, is for us as a department to be able to work through. And not only for SHRA, for all the entities. The presentation, as you know, Chair, it was late to you as well. So at the time that it was supposed to be presented or submitted at 12 on Friday, it had not reached the department. It reached the department on that Friday at about 5 in the afternoon, when the due date for submission here was 12. So it did not even meet the requirements at the draft level to even have a discussion with us. So Chair, I couldn't condone the presentation. And I subsequently wrote to SHRA to tell them that I deemed the presentation not meeting the requirements, not necessarily a presentation. I didn't even have time to look into it, but in terms of timeline of submission and the process of management from submission right up to the final signature and submission to the portfolio. And they wrote back this morning, of course, responding to my letter to say they wouldn't be traveling to avoid incurring fruitless expenditure because the presentation has not reached my office timeously for me and them to be able to engage. And Chair, I just want to close to, just to say to honorable members, some may even think there is I could have just let it pass, like I did previously. Unfortunately, then it was changed in the morning after I'd even granted that. Chair, I was sitting with quite a bit of a difficulty with some of our social housing, what do you call them, SHIs. Some have even sent sheriffs to deliver papers in my office. Some are in the process of being liquidated. They are writing letters. There are some even requesting at the higher office for intervention. I had a meeting with the chair and the acting CEO to raise some of the issues which I had an expectation that the chair and the board will take into consideration when they're dealing with the blocked project. So it was very difficult for me to just let it pass without that fair and thorough assessment which assists SHIs as well to be able to live by the mandate that the department had given them. Particularly the projects that were stalled during the COVID times and now need to be finalized and concluded. It's the same approach, Chair, we took with the provinces, particularly the Free State and the Northwest, and Gauteng, which had quite a number of blocked projects. We sat down, we took a principled decision that 80% of your budget must go back to the blocked projects. You can only utilize 20 for the new projects because you can't start a project, leave it at the roof level, and then go and start another new one. It just does not make sense. Rather take 80% of your budget, deal with what you have started, get the positive yield for it in the interest of the beneficiaries. So watching them closely as we would want to watch provinces in this principle of blocked projects. Chair, I think this is my sad explanation, but I'm putting it on record that I think I have done fair enough to assist SHRA, like I do with all the entities, to lift on the responsibilities that they are supposed to do as a board and undertake. And I'm not happy with the outcomes. I'm seeing progress in others, not that they're perfect, but I'm not happy with the outcomes. So the board chair said after the meeting, the deadline, they said on Friday, you guys want a report on Friday, that report wouldn't have met. The minister, I mean, yeah, it's just poor planning that is at the center of SHRA, and they are unable to come again to present to this committee. Thank you.
So you have raised your hands, Minister. Or Mudimuntush. God help us. Yes, we want to know whether you have raised your hands.
No, Chair, I haven't raised my hand. The memorandum of incorporation guides me on what to do. But honestly and fairly, as they were withdrawn here in front of you first time around, like I did with all the entities, I took the responsibility of meeting with them as I had committed, and not only dealt with block projects, dealt with quite a number of issues which they were having challenges with, and I offered to help. So there is clear guidelines on the memorandum of incorporation, but I equally couldn't come into this August house and give you a half-baked story that has not been thoroughly processed by the department. I have got experts that advised me. If I just accept a presentation without the input from DTG Ngongo, whose responsibility is to oversee entities, I just okay it. I'm also putting her in a predicament because she would have not been able to advise me appropriately. And I take that step very, very serious. I mean, when I'm coming to you on the Constitutional Court, here is our head of legal services who sits with me. If there's anything I submit to you that hasn't gone through to him, I may not necessarily would have followed all the processes that are needed for me to ensure and guarantee that the information, to the best of my ability, is what the department can put forward to come and present. And that's the discomfort that I have. That is why I'm saying, yes, I could have said, let them come, let's discuss it in front of you and turn you into a planning meeting as well. And I equally ask questions that I would have asked them in front of you. But that would be not honorable to you. It will be disrespectful, actually. It will be wasting your time. But it will also not be addressing all the key challenges of social housing that we have in the country and that I'm mandated to come and report to you, logically including a plan on how will I eradicate the challenges that we have. So, Chair, I will follow the memorandum of incorporation. And that is why, to me, it was important that now, instead of all the meets and whatever, I must put them to terms in writing, which is what I did after they did not meet the deadline that has been set by this House, to everybody, not to them only. And I will take it from there, Chair. So I'm not here to say I don't know what I need to do. I'm just explaining, Chair, that I don't have them with me because they didn't follow your own processes. Your submission, it did not arrive on time. And it's set for me.
Thank you. Honorable Poole.
Thank you, Chair. Chair, yes, I want to agree with what the Minister is saying. Of course, why there's a lot of citizens out there, especially stalled in their block projects while waiting for many years to become a homeowner. Previously, I think a few months ago, I asked a question and asked whether it is for us a benefit to go forward with entities not performing, or is it not the time to say, now it's a stop and we will find a means to fast forward the building of houses for our people in South Africa. And yes, we cannot, and we have portrayed accountability as a political tool right now, before this. But this is exactly what I'm talking about. SHRA is a crucial component to the department in for them in order to deliver the houses they have set them as a target. And they are part of it. But if they are not accountable in this manner, I don't see if we will reach the houses our people need outside. Thank you.
Honorable Gamede.
Thank you very much, Chairperson. No, thanks, Minister, for clarity with regards to the SHRA and not coming to attend our meeting today. No, Chairperson, I just want to, because one have seen this on media, former NPA boss faces a 6.7 million court claims over Gauteng housing project. Utate Bulelang Ngcuka. If a former NPA head and a private developer personally guaranteed that on Gauteng housing SPV that has now defaulted, what does this reveal about the due diligence standards? I'm glad because the DG is also here and the head of legal, or absence thereof, that allowed public adjacent housing delivery to be structured around private personal guarantees rather than transparent, accountable project finance. Given that the housing hub was operating as a special purpose vehicle tied to the Mohlakeng Extension 16 development, what oversight, if any, did the relevant provincial department or human settlements at a national level or municipality authority exercise over the SPV's funding structure before the default occurred, and were resident housing delivery timelines ever consistent on this now collapsed financing arrangement? My last one, Chairperson, does this default at Mahlakeng Extension 16 point to a broader pattern consistent with SHRA's 553 million rands in blocked social housing projects of human settlements delivery being financed through fragile high-risk private lending structures? And if so, what systemic reform is needed to prevent housing beneficiaries from being caught in the fallout of failed private guarantees? Thank you very much, Chairperson.
Thank you, honorable members. Minister.
Chair, thank you very much. I agree in entirety with the Honorable Pool. We need social housing. We need SHRA to really be on their toes and assist in the mandate of the basket of human settlements. And I think us getting it right, myself in particular, is of importance to the committee and the work that we should be able to undertake. And Chair, as I indicated earlier, it's that I need to make sure that I carry the responsibility of bringing it online, continuously reporting to the portfolio. Honorable Committee, I will avoid that we single out one project, and I will tell you why. There are many. That is why the 80% principle. And I want us to not to focus so much on the percentage, because one area can differ with another. But the principle, I mean, you go to Tembisa, for example, Egurule, there are many block projects. You go to, Mama Kakula fights me all the time. Yay! Finish! It's not that I'm not listening, Mama, I know. You go to Gauteng, you go anywhere else, there are many incomplete projects. Now, the logical thing to do, without even arriving at the percentage and the budget, is to say, this is what I have. How best do I address the intention that I had to complete it, conclude it, before I even undertake new projects? That was the principle that we adopted at MINMEC, all of us jointly. We did not want to decide for them. It's still not our intention. We said, board, go back, the same way as we did to the province, and go back in your business plan. showcase what is new, what is old, what do you have, how long will it take you to cover this, considering the beneficiary who has been there waiting for a project that is still incomplete. Now, they are supposed to sit and say, with the 500 whatever that we have, this is how far we can go. And these are the reasons why we have prioritized project A versus project B. What are the challenges in the others, and what is the plan going forward? That's the main task that today was about. It was about us coming to convince you to say, in the greater scheme of things, with everything in the box, we believe that we need to start and unlock and unblock here and whatever, using the board taking its own determinations as their fiduciary responsibility for social housing. Now, that's what seems to be a difficult task. But second to that, besides even the liquidations and whatever, central, the biggest loser here is this beneficiary who is seeing a building that got stuck at roof level for 3-4 years, and there's just nothing that is happening. You know, we may calculate the figures, but that injustice, we can't calculate it, and it's so grave. It is so big. So primarily is this unblocking. It's not necessarily even about the budget or any other thing. It's about this beneficiary who so deserve to get this facility going. But it is even worse when SHIs have had an agreement with us. There were challenges for one reason or the other. They are now even being liquidated. You are citing a case which was on a newspaper. They have been writing to my office. We have been engaging with SHRA. They are not the only ones, actually. When I'm saying we are now being served legally, responding to SHIs which are now facing liquidations, some for young people who have been starting to be developers and doing a great work. Some are even presidential projects. They were not even launched by the minister. They were launched by the president, realizing a need for social housing. So we've got quite a lot of pressure to make sure that we get it right. So, Chair, I wouldn't want to respond directly to the issues of due diligence and Muhlakeng, but the task was about exactly doing that. Muhlakeng is just but one. Chair, we have got around 212 blocked projects. 212. In our plan, we were trying to deal with about 85 GG, if I remember my targets very well. Of these 212, this shows that planning is an integral part of what we need to do jointly, ourselves, HDA, each and every cent that we have. We need to channel it more, either into a gogo who's standing in front of a slab and her RDP was not concluded, or it's a high tall rise building that social housing is supposed to provide, etc. We are stuck there. We need a board that must come to the department, put a convincing case, outline it, and the department comes jointly to you and say, like we did with the provinces, we're highlighting 80% in this province because this is their backlog. We're highlighting this much percent in this province because this is their backlog. We want to do the same with SHRA, and that is why we made an undertaking for unblocking of projects. We hope we'll be able to find one another, Chair, to be able to come back to the portfolio. And the people of Mhlakeng, we are doing all our best to get the projects rolling, not only them, 212 of them. That's the backlog that we have, which we must periodically report to you. And I would like to believe that you want a sound explanation that takes into consideration this entire backlog. But I must also emphasize, Chair, this 212 is not only about SHRA. It shouldn't sound like it's social housing, no. It is overall the backlog, where we have calculated an incomplete house, a house that was not built properly by a contractor that possibly need a retake, or a building that was half. So all of them, your Monroes and your whoever, they belong in this 212 countrywide. That is why our target is a bit high, because there are provinces which need to be taking more than the other in terms of the backlog of the 212 projects. Thank you very much, Chair.
Thanks very much. I think this is the second time that we're supposed to receive a report from SHRA, and there's no report. If firstly, as a committee, we'll get a legal opinion as to how do we move forward, because we must be able to do our oversight. Secondly, Minister, you and us were elected by the citizens, and the President gave you a responsibility to drive a program of giving our people housing. You appointed entities like SHRA to assist you in that regard, and they are failing. They are failing. I said in my opening remarks that they are halfway their term of office. And the reason why we, as part of our agenda today, we requested entities to talk to us about governance issues, are informed by such things. I'm aware that you had a meeting with the board of SHRA or the council, and they are not coming to the party. It means they are undermining the executive authority that has appointed them. And SHRA is not there out of favor. They are there because there is a need. They are established by the Act to assist the minister with all these things. I can read from the Act that establishes them as to what is it that it is expected of them. And they are failing. And okay, we'll give you an opportunity, Minister, to deal with it, but I don't think you are going to succeed. Even if you were to succeed, by the time they start planning to implement those blocked projects, remember that was a resolution of this portfolio committee after their oversight. This committee did an oversight and found a number of blocked projects. Talked to the communities. Communities are frustrated. Beneficiaries have been waiting for long, and we still have our issues in our boardrooms, which I don't think as Parliament we can accept. And if you don't take action, Minister, my intelligence tells me that even in CISOs, there are some such challenges coming up. And if we don't take a decision and set an example, we're going to have a problem. And maybe it's also time to initiate discussions as to whether we still need these entities in their current form. And we talk of merging them, some of them, and so on and so on. Because these people applied or nominated to serve on the board, and they're not doing what they're supposed to do. We met with them, was it February? We're supposed to meet with them in June. Now, what are they doing on a daily basis? So I'm not necessarily dictating, Minister. But at some stage, we may have to also, that's why I'm saying we will need a legal opinion from our parliamentary legal office as to our options. And if it comes to a push, you may even have to take a report to Parliament for Parliament to resolve. But we'll wait for your interventions and see how far they go. But if you had that heart-to-heart meeting, as I was told with them, and they still don't respond, I don't think they're still interested in the love affair. Because you had heart-to-heart meeting. I don't know what DG Ngongo will say, but I take she's monitoring on a daily basis, doing oversight. And some of these things must come to light early to show that we're not on the right track. Because they are not there to occupy office, but to assist all of us to make sure that we're now busy with campaigns. We're being told this and that because people are sitting in offices in SHRA and they don't want to. We're even afraid to go to Mafikeng because you'll still be asked about what do you call it, that project? Marang. He has just talked about issues that were in the media. And we can't. And the public out there sees this minister failing to deliver. Harnessing them and so on and so on. I don't know. But I think I'll pester you, Minister, with phone calls to see how far you get there, because where I'm sitting, I don't think they're interested in what you have appointed them to do. They're showing signs of undermining you, and they are appointed by you. If I appoint you and you undermine me, it's a problem. But maybe give us a feedback soon so that we also know how to take it forward. But they are not there to assist us, and they will never assist you. And when you are being assessed at the end of the year, both as a minister and as government, will say we have failed. For 3 years, we have failed our people. In my opening remarks again, I talked about the opportunities that are there in Polokwane and other cities, Mangaung and so on, about social housing. We'll never achieve that if we still have people who behave like this. We'll never achieve that. Honorable Detail.
Chairperson, thank you very much. Perhaps I should have spoken before you did. Perhaps I know that the minister is indeed intent on doing exactly this, but I think if we can have an algorithmic approach, a step-by-step approach to say, these are the actual steps that I'm going to take to remedy the situation so that we can support the minister. Because, Chair, while she herself does oversight over these entities, she certainly needs us. And I think from the point of view of oversight on our part or from our vantage point, it is important that we know exactly what the minister is saying. Just an example, the president, for example, announced the National Water Action Plan. That National Water Action Plan is very clear in terms of things such as the water boards, preventing sewage pollution, maintaining river health, et cetera, et cetera. So there are those specific steps, and I think that's what we should ask the minister to do, so that in line with what you've said, Chairperson, we can then contemplate what way forward we should embark upon to do this. Because the issue, for example, of Tafelberg, that is important, but it is also inextricably entwined with entities such as SHRA. And these are the very vulnerable people, sections of our population that whose well-being, in line with the Constitution, we must preserve. So we will appreciate that so that we can support the minister, because that's how it works, Chair. There are things she can do, but she can do them better if we support the minister as Parliament. Thanks.
The Premier of Limpopo did an oversight in one municipality, Mahalakwena. Found sewage running throughout the streets. She immediately instructed that the municipal manager must be fired. Council did that. Municipal manager went to court, lost. He went to court again, lost. Because what he is employed to do is to provide service. And when there's no service, there's a spillage there. What is he there for? I'm just citing that as an example, Minister, to say, if SHRA is not there to assist us with the social housing issues, why are they there for? I know sometimes we are afraid to take radical because we are afraid of the court will blah, 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 and so on and so on. I'm giving this example with the Premier of Limpopo. Thanks very much. We leave it in your hands, Minister and Deputy Minister. But I'm going to call you now and then just to check how are you doing so that we are able to deal with it. Yeah?
No, Chair, you're saying you're going to check how she's doing. Now I'm asking if she says she's critical but stable, what are you going to do?
We'll get
I will still be
we'll get an
stable,
independent doctor. Okay, thanks. Let's pass that item. With that understanding, we'll get a report from the minister. But like I say, let's act. Otherwise, you're going to experience problems with these other entities. Like I'm saying, I'm putting it on record that in CISOs, there are signs of that kind of behavior. They're starting to emerge. We're still checking other entities. So if you leave them to behave like that, we're going to have a problem. Let's go. Would you be happy to have a 10 minutes comfort break?
We're in your capable hands, Chair and honorable members.
Okay, let's have 10 minutes comfort break. What time is it now? 11? Let's come back at 10 past 11. Is there tea? I think there's tea outside. And Casey, can you work on there's aircon here. Yeah. They are lying when they say there's no aircon.
differ in proportion and they differ in what are the issues about. But we're finding stability in NHBRC. We've dealt with the issue of the CEO. We are at the recruitment level, or should I say they are at the recruitment level for the replacement. The cases have been closed. We're finding stability at HDA. There were challenges. They've now put and compiled their project register, and the board is assisting. We've also met with them. We're trying to deal with the PPRA issues in relation particularly to the liquidity and issues which relate to the labor union. And these issues are very historical, Chair. You will recall that at the time some of the labor conditions were agreed upon. It was even before this board. But DDG is steering the ship to try and make sure that all things are accustomed. Some boards are stronger than the other. You know, PPRA started at the back footing. I think it had about 3 or so vacancies. The same with CISOs, but you can see that even those who have come in now, or when I'm saying now, after the official appointment of the others, they are catching up, and there is direction, much as there are still challenges. Key for us is that the entities must be able to fulfill their mandates, navigate through the difficulties, and the department is always there to assist them. So there are 2 chairpersons, Chair, as noted earlier at the opening of the meeting. Females, it's Women's Month. It's important to appreciate their leadership with vision and how they are steering in the difficulties that they are facing, but nothing insurmountable, Chair, and will provide full feedback on the issues of CISOs and the issues of PPRA and overall in relation to entities. With your permission, Chair, I think you can steer back into the meeting. I just wanted to give a sense of comfort and direction that it is not all lost. Thank you very much.
Thank you. Happy Women's Month. And I don't know whether you got a message. We send a message that says chairpersons can be accompanied by 1 or 2 board members. You didn't get that?
Yeah, I don't recall your letter, Chair.
You don't? Okay.
But some are not in good financial
Yeah.
condition. We always say they must prioritize the costs. I mean, I received, for example, the a memo from Chairperson Zoe yesterday seeking to approve a CSI policy at 1%. I just declined it, Chair. I approved the policy, but I said no one can CSI now. Not for now, because they simply are having a difficulty with. There's nothing wrong with the policy, but there's everything wrong with us going through towards CSI as if our mandate is ran fully and the way we would want it to be. So that could be another reason. I didn't check, and I do accept that they may be needing some support, but we are here, Chair, to assist one another. Thank you.
Thank you. And these are the 2 entities, if they were to work very hard, they can raise a lot of money. Thank you very much. Chair?
Thank you, Chair. Chairperson of the Portfolio Committee, members of the Portfolio Committee, Honorable Minister, Deputy Minister, fellow colleagues, chairs of entities, TG, DTGs, and the entire team from the department, CEOs and CFOs of entities, all protocol observed. Good morning, and thank you, Chair. On behalf of the board of the CISOs, I'd like to express our appreciation for this moment to come and appear before the Portfolio Committee today. We recognize and value the committee's constitutional oversight and in ensuring that public institutions are accountable. The work that they do is transparent and responsive to the people of South Africa. We welcome this engagement, Chair, as an important opportunity to account to the Portfolio Committee and to the people of South Africa for our stewardship of the organization and to outline the steps being taken to strengthen its performance. Chair, in your opening remarks, you touched on the basic principles and values that our portfolio needs to keep in mind, but mostly the why, which is underscored by the Constitution. The role of CISOs comes in further here to say it is to protect the value and the sustainability of access to that particular land, Chair. While the government's responsibility is to help citizens access that land, community schemes and this is CISO's responsibility in that those need to be governed fairly and disputes are resolved amicably and efficiently, and residents can enjoy secure and harmonious living. In that sense, Chair, CISOs is an essential institution in the human settlements value chain. Chair, I digress, noting that you have indicated in your opening remarks as well that most of these boards have been in operation and in existence for 18 months. And this board, the Board of CISOs, has been in existence, operating fully, Chair, for just over a year. Actually today, 5 days, just over a year. But having said that, Chair, I'm not trying to say that there should be less expectations from the Board of CISOs, because the board came understanding precisely what was ahead of them, and the board still remains committed to promoting sound governance, ethical leadership, and prudent financial management, while supporting the executives in delivering on the mandate entrusted to the CISOs under the Community Schemes Ombud Services Act. We acknowledge that there are challenges, Chair, that require our attention. I think you've alluded to some of them. And we are quite grateful that we do get the support from the department, and in turn we see that the Portfolio Committee itself is committed to ensuring that those challenges are addressed. And Chair, whilst having said that our focus is clear, is to offer oversight, robust governance, and continuous organizational improvement. And Chair and Committee, to that effect, even in an incomplete term, the CISO still received an unqualified opinion for the 2025-26 financial year. Today's briefing, Chair, covers key aspects of the organization's performance, including governance, financial management and sustainability, operational performance and service delivery backlogs, compliance, stakeholder relations, as well as ICT and data management. These are the areas that the board continues to monitor and to prioritize through its oversight responsibilities, to ensure that CISOs remains financially sustainable, operationally effective, and responsive to the needs of the community schemes across the country. Honorable Chair and members, we appreciate the committee's continued guidance and oversight, and today we look forward to a constructive engagement, and we will respond candidly to your questions and observations. Thank you, Chair. If you'll allow me at this time, Chair, I'm going to call on the executive management led by the Acting Chief Ombud and Acting Chief Financial Officer interchangeably to lead the presentation. I think, Chair, whilst at that, I mentioned the Acting Chief Ombud and Chief Financial Officer. And probably one question that comes to mind immediately is about the acting situation. And from that perspective, Chair, in the period that we've been in, one of the most important things that we needed to do was to stabilize the entity, and to that effect, I'd like to report that the recruitment processes have undertaken, and I think before the end of the week, the minister will be receiving the outcomes of that recruitment process, which would then inform how we as a board see how to stabilize the entity. Thank you, Chair. And Tate Kamal?
Thank you very much, Chairperson of the CISO's Board, Ausbusi. I hope I'm audible, Chair.
Yes, you are audible, but just to say, as a principal, we have received your presentation. Don't go line by line. Yeah,
Noted,
all right.
noted, Chair. Before we jump into the presentation, let me start by greeting Chairperson, greeting members of the Portfolio Committee, the Honorable Minister, the Deputy Minister, DDG and DDG, fellow colleagues from sister entities, all protocol observed. My name is Retabile Hamadi. As Ausbusi has already indicated, I'm the current acting chief ombud for the community scheme ombud service. So with the presentation, we'll be covering the purpose, the mandate, governance, operational and service delivery backlog, oversight, financial management and sustainability, ICT, stakeholder relations. Then we'll close there with the recommendation. So the purpose of this presentation is to brief the Portfolio Committee on CISO's governance issues, and the briefing have already been indicated from the outline. The mandate of the CISOs, as stipulated, clearly stipulated under Section 4 of the CISOs Act, is to develop and provide a dispute resolution service for community schemes, provide training for conciliators, adjudicators, and other employees of CISOs, regulation and quality control, regulate, monitor, control the quality of schemes, governance, documentation, and lastly, take custody and public access. That is to take custody of, preserve, and provide public access electronically or by other means to schemes, governance, documentation. Then here, Chair, we're talking to the composition of the board. As flighted on the screen, we have Ausbusi as the board chairperson. Then we have Marina Dumakude as the deputy chairperson, Mapi Folitsie as the non-executive member, Karen Muten as the non-executive member, Lerato Muamoha, Heinrich Eibrel, Mduduzi Zungu, myself, and the acting CFO on my right. That is the composition of the CISO's board. In terms of oversight, we have 6 governance committee. We have the governance committee, which ensures a robust and effective process. We have the HRMCO, focuses on performance and remuneration for CISOs. You have the finance committee, which assists the board in discharging its duties in relation to governance and oversight regarding financial management. Then we have the audit and risk committee, which assists the board with oversight of financial management and reporting. The social and ethics committee, which assists the board in setting the ethical tone within the CISOs. And lastly, we have what we call the LATCOM Legislation Adjudication and Transformation Committee, which assists the board with exercising oversight over the core regulatory business of CISOs. Then in terms of the board mechanism, we have the executive authority which the board reports to, implementation of the shareholder compact, compliance with the legislative and policy framework. There's the board charter and the board code of conduct in place. The board committees, the 6 board committees which you've already touched on. And lastly, we have quarterly reporting and monitoring. Then on this slide.
Recording stopped.
On this slide, Chair, this is just to sensitize the portfolio committee on the CISOS delivery model to say CISOS, we are regulating and governing the community schemes by identifying and registering schemes and issuing registration numbers. We collect levies, we enforce provision of the Act with other regulatory bodies. We also do that by ensuring that we issue compliance certificate. Lastly,
Recording in progress.
if there's any dispute within the stakeholders that we are serving, they can follow dispute mechanism that we have with the CISOs. And obviously with that, we maintain that by ensuring that there's continuous stakeholder relations through marketing and communication. Then the service delivery backlog for registration, we're targeting 100%, which is 4,000 registration of community schemes in the current year. Then in terms of the backlog, we are saying without universal scheme registration or a complete accurate national register, CISOS is constrained in regulation. And what will be the corrective measures for CISOS to address this challenge is to implement a community scheme registration strategy to map the full universe of schemes, meaning we'll be implementing a national data acquisition program, implement a provincial registration model, develop a data management framework, awareness and stakeholder activation, and the strategy runs from 2026 until March 2030. Continuing with levy compliance, the target for the current financial year is 77% of registered billable schemes paying levies. In terms of the backlog, we are saying non-payment of levies by billable schemes weakens the revenue base, raises outstanding data balances, and constrains CISOS financial sustainability. And what are we doing to correct this? Is to improve billing accuracy and strengthen debt collection through timely invoices. I will not go line by line, Chair, as you indicated. Then in terms of compliance, I think it is also worth mentioning, Chair, that Section 34 of CISOS, which talks to offenses and penalties, does not really empower CISOs, in terms of, enforcing, and this is, a very big gap for CISOs, because you have schemes that are intentionally not complying. And unlike, the big brother, the receiver of revenue, if you're not paying or not submitting your returns, SARS can be able to act and ensure that you do submit your returns. It is not the case with CISOs. And currently we are busy with the legislative review of the CISOs Act to ensure that, these gaps, they are being addressed. So here we are saying 78% of annual registered community schemes compliant. Corrective measures to implement a community scheme compliance and enforcement strategy, which will cover the implementation of a compliance maturity model, conduct national scheme compliance drive, community schemes visitations, issuing of verification letters and non-compliance notices. Then in terms of the dispute resolution, where we also have a backlog, but it's also worth mentioning that CISOS is trying by all means to reduce the backlog, as quickly as possible. As at December 2025, the backlog was sitting at 11,838. And as at 30 June 2026, the backlog is sitting at 4,810. So, Chair, we can note that, the backlog has been reduced by just over 50%. And in terms of the corrective measures, we are saying we need to expand the capacity by appointing additional adjudicators, continuous enhancement to the Resource Connect dispute resolution model, conduct webinars on the use of CISOS Connect. Then the legislative framework, like any other government entity, the CISOS does not operate in a vacuum. There are laws that we need to, adhere to, which I will not go, bullet by bullet. Chair, the first one being the PFMA, the Sectional Title Schemes Management Act, the Companies Act, Property Practitioners Act, Protection of Personal Information Act, which is very, very key to the business of CISOS. As we know that CISOS does not own any buildings, does not own any fleet. The biggest asset that we have as an entity is information, and we have to ensure that we protect information of our stakeholders. Then in terms of compliance of the sector, we are saying we need to implement a compliance maturity model, conduct a national schemes compliance drive, issuing of verification letter and non-compliance notices, and lastly, validation and verification phase 2 post-implementation of CEIs. Let's see. I will then hand over to the acting CFO chair to take the committee through the financial management and sustainability section of the presentation.
Thank you, Ako, Chairperson of the Portfolio Committee and the members of the committee, Honorable Minister, the DM, DG, and DDGs, colleagues. I'll take a cue, Chair, from the fact that the presentation has been circulated. I will only touch on those sections that requires a little bit of information, Chair. The first presentation will be looking at the financial overview of the entity. Chair, in terms of the CISOS Act, CISOS relies, it's actually primarily funded from the CISOS levies, which constitute around 98% of its revenue, and then 2% it's only coming from our interest that we earn from our call deposit. I must mention, Chair, that in terms of the Act 22.1, one of the sources of funding for CISOS consists of money that is appropriated by Parliament. However, this, Chair, has been discontinued. And I think it's important that I provide background to discontinuation of this grant. There was a time that CISOS was financially stable. and it did not make sense at the time that we'll get a funding, for example, of around 20 million, but then when we have to surrender money to the treasury, they take around 100 million. And I think it's on this basis that we're seen to be financially sustainable, independent, for that matter, that this grant was discontinued. However, at the time, CSOS was very manual orientated, and it did not make sense at the time that CSOS will, as a regulator, will, operate on that space when the rest of the world has actually moved into a digital platform. We made a commitment to develop a system, which is, I think by now is known to be CSOS Connect, and I think I must also indicate that when we're implementing this project, it is the time that National Treasury, in terms of Section 53, thing 3, they took over. I mean, they took money from us. And by the way, Chair, today, I think we account to almost $500 million that has actually been surrendered to the National Treasury. And I think this is one of the things that actually got CSOS to be where it is today on this financial sustainability challenge. Chair, we have seen in the past years a decline in the collection of revenue. This was actually compounded by the increasing operating cost, but also on the commitments that we made, that we actually had to fund from our revenue that we were actually collecting. We looked, Chair, into our finances, and then we had to come up with a way in which we could actually get out of this situation. One of the ways that we implemented is to contain some of the expenditures. We developed a cost containment expenditure, but we also developed a revenue enhancement strategy that will see us, collect more from the schemes as we are regulating. Some of the initiatives, Chair, that we have implemented so far is to embark on a quarterly review process whereby we align our collection to the expenditure, so that we don't come across spending more than what we have actually collected. Chair, I want to take the committee through the profitability of the organization. It's important to note, Chair, that in the Q1 of this financial year, we have actually seen a huge improvement in terms of our profitability compared to the same time in Q1 last year. In Q1 last year, Chair, we had reported a deficit of 5.9 million. And in this year, in the same quarter, we are recording a surplus of 9.5 million. That is a major improvement, Chair, just to turn that around from a deficit. But further, Chair, when we look at our revenue sustainability, we are largely dependent on CSOS levies. It's important to note that for the Q1, we have actually achieved, in terms of collecting more than 75%. However, Chair, we note that we under-collected in terms of our projections by around 13 million for the first quarter. And this is something, Chair, that we need to look at going forward. And I'll speak to some of the initiatives in the next slides, how we're actually going to recover from this underperformance. In terms of our liquidity, Chair, you will note that in our financial statement, we are recording a higher amount of liabilities. And I think it's also important that I provide this to the committee. Almost 85% of our liabilities, Chair, it's relating to unallocated levies, and it's also relating to the revenue that we receive in advance. These are the schemes that they pay, whether for 2 quarters or they pay over a period of a year. This revenue, Chair, is what is actually drawing CSOS below the acceptable level of its liquidity. But it's also not to say that, Chair, we do not have challenges as far as the revenue collection is concerned. If you look at our expenditure for the first quarter, Chair, compared to last year, we're able to, spend almost 72 million compared to over 84 million that we spent in the last quarter at the same time. This, Chair, represents an improvement as far as the expenditure is concerned, as we've implemented this initiative of containing some of this expenditure. And I'll also speak to some of these expenditures that we have actually contained. I've already spoken about the balance sheet view, Chair, in terms of the unallocated levies, the total asset and total liabilities. Our plan, Chair, is to turn around the organization over a period, and this is more realistic, Chair, if you look at our financial position, over a period of 18 to 24 months, where we'll see to have, be able to report even a sustainable surplus in the organization. But we've set ourselves a target in terms of collection. We're targeting 85%, and I think the question that the committee might be asking is, why are you not collecting 100% of that? Chair, from our analysis, it shows that there are schemes that are in financial distress that are actually entering into a payment arrangement that, they're not able to pay in full the amount of money that they're actually owing us. One of the interventions that we've also embarked on, Chair, will not be able to grow or to be financially sustainable, Chair, if we do not increase our revenue collection through our scheme registration. This, Chair, will enable the organization to remain financially sustainable. Chair, the next slide is just a cash flow movement. And I must say, Chair, that in the first quarter, we project to, at the end of the quarter to be overspending by 11 million compared to the previous financial year where we've actually overspent by over 40 million. That represents a recovery over a period of 12 months. As I indicated, Chair, that our plan of recovery spans from 18 to 24 months. These are some of the containment strategies that we've implemented in the organization. I'm not going to go through one by one, Chair. As I indicated, I take the presentation read. One of the areas that we are guarding against is the use of consultants, Chair. And I think it's important also to note that will obviously exclude our part-time adjudicators that are also helping us to address the backlog that the acting Chief Ombud has spoken about. The issue of travel, the issue of advertising, where we have seen in the past years to be spending a little bit more instead of now resorting to using most of our media and digital platforms that we could still, make the CISO's presence felt. Chair, it is good to note that, from the first quarter, we seem to be making progress. But this, Chair, is taken with caution as it is a temporary arrangement that we're having where we are looking at factors as delaying some of the projects and then also looking at our vacancy rate, but also looking at some of the list options that we have. Chair, this is not to compromise our performance, our APP, because I'm happy to even to announce that in the first quarter, we've actually achieved over 83% of our APP in the first quarter. So it does not compromise the achievement of these targets at the end of the day. And that is the end of the presentation from my side. Thank you, Chair.
Thank you very much, Acting CFO. I will then now wrap up the presentation, Chair, which covers one of the briefing items, which is ICT and data management. What is CISOS doing in terms of ICT and data management? So there's a number of initiatives that CISOS has embarked on in order to be a digitally transformed entity. And one of these initiatives is the implementation of the electronic content and document management system. You may recall, Chair, that CISOS, it's a 10-year-old entity, and its initial stages, most of its work was manual work, where stakeholders were required to fill in, your CS1 forms, and we have all those stacks and stacks of documents in our storage. So the aim of this project is to ensure that we scan and make sure that there is, information in case it's required, in future. The CISOS Connect, which is one of the key projects in order to automate our core business, that is the registration of schemes, compliance, then lodgement of dispute. This is one project that we've been demoing, in particular during the CISOS Indaba. Chair, I'm yet to see a public entity that has demoed their system live to the public. This is something that we post about as the CISOs, that, you know, we are being held accountable as the entity. Then the ICT infrastructure, the cyber security strategy. As we embark on a digital transformation journey, it is also important to ensure that we protect the digital assets. So the strategy covers the roadmap to strengthen the cyber resilience, the ICT policies and standard operating procedures. We also have governing structures, your management committee, your executive committee, your audit and risk committee, and lastly, the cyber awareness that is continuous throughout. And in terms of advancing data governance, we have continued implementation of data governance practice to improve data quality, alignment of data management initiatives, and enhance governance oversight to support regulatory compliance. Then moving to the advocacy and stakeholder education, Chair. The CISO's legislative mandate is to provide education and information, which is something that we've covered earlier on in the presentation. I will not dwell too much into it. So part of the advocacy plan is to conduct regular stakeholder information sessions as part of its advocacy plan. These sessions provide education on legislative requirements, governance principles, and compliance. And lastly, to support the sector by enabling CISOs to address emerging sector issues, respond to stakeholder queries, strengthen understanding of the regulatory framework. And in terms of the industry engagement, CISOs engages key industry bodies such as NAMA, National Association of Managing Agents, your ARC, Association of Residential Communities, on quarterly basis. And in closing, Chair, the recommendation, we are requesting that the Portfolio Committee notes the governance issues of the CISOs as highlighted in the presentation. Thank you very much, Chair.
Thank you. Are you fine, Chair?
Thank you, Chair. That brings to the end the presentation from ourselves. Thank you, Chair.
Okay. Let's get a presentation from PPRA. We're going to deal with them together. Your slide has 27. Your presentation has 27 slides, but you'll talk to them. And there were additional questions sent to you, you remember. Chairperson? Put your mic on.
Honorable Chairperson of the Portfolio Committee, Honorable Minister, and the Honorable Deputy Minister, the DDG, and the DG, together with the team, fellow chairpersons of entities and the executives. I greet you all. I'm elated and honored to be here. I am accompanied by the CFO and the CEO. We pledge as the PPRA to continue as much as we can to implement the legislative mandate in accordance with the vision, the mission, and the values of the organization. We embrace the fact that now we've come to terms with the fact that we are self-sustaining, and for our sustainability, we have commenced projects of being innovative. There's a task team that has been formed to look at how best to bolster our financial and improve our going concern and the financial status, and improve on our ICT and our audit findings. We have made marked improvement, and in collaboration with the audit committee and the AG, we are optimistic that we are on the right track, and what has been identified, we managed to clean up most of the backlog, and even we are on our way to firm up our ITC system. However, I will not elaborate on this because we've got a well-documented report that has been to the board, and I'll hand over now to the executives to elaborate and expatiate on how far we've gone and where we are going. Thank you, Chairperson.
I didn't hear you well. You said, what did the auditor say?
You mean the AG? We still do have a qualified audit chairperson. However, even themselves, they considered that we have really improved in many aspects. And we are continuing to improve, and there's a plan in place to address all the other hiccups.
Okay.
Yes, Chair.
No, I was surprised by Professor Wasabuleli Kalena. So I go go which. Okay, CEO.
Thank you, Chairperson. Good afternoon to yourself, honorable members, the DG, the minister, the deputy minister, executives from the department, chairpersons of boards, and my colleagues. Chairperson and honorable members, yes, there were questions that were posed to us, and we did incorporate them in the presentation, Chairperson. So I will touch on them as I present. Chairperson, one of the President's key messages in this year's State of the Nation address was that South Africa must create conditions for economic growth by making it easier for people to participate in the economy, reducing unnecessary barriers, and expanding opportunity, particularly for young people and small businesses. It is in that spirit that the PPRA has introduced a significant reform through an alternative competency-based pathway into the property sector. This reform seeks to broaden access to the industry and accelerate transformation while maintaining rigorous standards of competence and consumer protection. I am pleased to advise the committee this afternoon that this new initiative has been widely welcomed by the industry and has received the formal support of the National Property Practitioners Council, which is the NPCC, and this body represents 8 national industry bodies. The South African Youth in Property, which is SAIPA, as well as the support of many historically disadvantaged property practitioners and leading real estate companies. It will move thousands of serial candidates, chairperson and members, which is an issue that we have seen throughout the years. And these candidates will be turned into non-principal status sooner, creating a stronger pipeline of future principal property practitioners, business owners, and entrepreneurs. Our own data at the PPRA presents a compelling and
Your slides-
unavoidable conclusion,
Are you on
Chair.
slides?
No, I'm coming there, Chair.
Okay.
The existing qualification framework, which is failing to progress candidates through the system in the manner originally intended, Chair. And just to paint a picture, Chair, from 2017 until 2025, we have issued over 330 FFCs. And of those, 179,000 are candidate property practitioner FFCs. And about 14,000 of those completed their NQF level 4 qualifications. So on average, almost half of all registered property practitioners remain candidates. What is even more concerning is that only a small percentage of candidates complete their prescribed NQF level 4 qualification each year, while the number obtaining equivalency exemptions is similarly modest. So here, Chair, the issue is not whether education is important, but the issue is whether the regulatory framework is achieving its intended purpose. So a regulatory system must be judged by outcomes and not merely by intentions. Chair, it was important that I start in that manner because our presentation, we were asked to obviously talk about our mandate, and in the main transformation of the sector is our key mandate, Chair. And we've come to this committee, and one of the things that we've been asked over the period or the last couple of years since the promulgation of the Act was, we're always talking about real estate agents, but what about other subsectors? So here, Chair, it's a picture, outlining the strides that we have made in ensuring that we onboard other subsectors into our regulatory fold. And you'll see that attorney employees are leading the pack, followed by managing agents. And chairperson and members, you'll recall that managing agents is where we have a overlapping mandate with CSOS. And here, Chair, is the registration of the previously disadvantaged agents with FFCs. And you'll see once again here that from 2023, since the PPA was promulgated to current, we have issued thousands of FFCs to PDIs. And this is increased, these numbers have increased by almost 100% in just under 3 years. And then the full status agents and principals, again, PDI's, Chair, we are painting a picture here. And the reason why, and this is one area where you would have seen in the last financial year, is one target that we did not meet of onboarding principal in the sector. And that's why we still have thousands of practitioners as candidates. And it is because of the expensive and unavailable NQF level 4 and NQF level 5 qualifications. That is why the new pathway that we've introduced is critical to ensure that they are full status practitioners in the sector, because full status practitioners and principals mean entrepreneurs, it means business owners, and it means more commission, chairperson. And then here we just, extrapolated again the PDI principals by race, and you will see the numbers are still skewed. That is why our pursuit of transformation we cannot turn a blind eye on. I mean, if you look at our white counterparts, the principals, who are the business owners, the numbers are 10 times what our PDI numbers look like, chairperson and members. This slide we included, Chair and members, once again to paint a picture, because we always talk about transforming the sector. We're always talking about, changing the demographics of the sector. But if we are transforming the sector, these new entrants, what are they coming into? And this slide talks to the economy in the real estate sector that they will be participating in. And this slide was taken from Stats SA, and it illustrates the number in 2024, the income that was generated just in the real estate sector alone. And you'll see that, Chairperson and members, from 2024, we are sitting at about 1.8 billion. And this is just commission that is going to our stakeholders, who are the real estate property practitioners. And I'm sure by 2026, this number has increased significantly once again. And once again, this slide, Chair members, it talks about that real estate activities was the largest contributor to total income again in 2024, and it's leading the pack by far if we compare it to other industries in the sector. So that is why it is so important that the role players that we have, are a representation of the demographics of this country, particularly PDI's chairperson and members. So that still remains the core of our mandate as the PPRA. And Chair, the board committee governance structure, we did not say who the board members are, because I believe this committee and our principals know who the members are. But we just wanted to highlight that the board is supported by 7 subcommittees, as we have stated in the slide, Chairperson. And they do meet on a quarterly basis or on a need-be basis. And then this slide talks to our operational and service delivery backlog. And what we are highlighting here today to the portfolio committee members is the enforcement and investigations business unit. So this is where consumers come when they have they're seeking recourse, or they've got complaints that they're lodging against property practitioners. And you'll see, Chairperson and members, that in 2024, 2025, we received almost 2,000 complaints. And of those complaints received 2 years ago, we only have a backlog of 93. And then in the current year under audit, we had 1,600, and the total backlog there is 86. And you will see the reasons that we stipulated there, Chair. And I think it's worth noting that this is one area I know consumers, when they are not satisfied with the outcomes by the adjudication committee of this business unit, they then believe they can come to either the department for escalation or for appeal of these matters. But the next recourse, obviously, is the court of law. And Chair, here, the reason for the backlog really is because of the vacancies that we currently have on our structure. And you'll understand why, Chair, when the CFO comes in after me to just give the financial sustainability of the PPRA. But we have made an undertaking that we will be onboarding interns before the end of this month, in partnership with Services CETA, to ensure that our under capacity does not affect our service delivery, Chairperson and members. And then again, this department, the system had been manual intensive, but we have upgraded, we are in the process of upgrading the system that we currently have relating to the investigation and enforcement business unit. And then, Chair, the next slide, this is where we were asked by the committee to outline, one, are we implementing our legislation as a PPRA? And obviously, Chair, we've got 77 sections in our legislation, so I couldn't come to this committee and say all of them, but we amplified the most important ones, which talk again to our mandate and to consumer protection. And Section 51 in particular is where, the section that prescribes that all property practitioners must maintain trust account with various banks. And this is one provision where we are 100% complying with Chairperson and members. And then Section 54, subsection 4, where banks are supposed to submit to us on an annual basis a certificate of interest earned on trust accounts, Chairperson, which they have been doing. So at any given time, well, once a year rather, we do know of all the property practitioners in the country what is the interest that they are earning. And this is the section that the chairperson earlier spoke of when she said that there has been a task team that has been established to ensure that as a regulatory body, we do then collect all the interest that is due to us, Chairperson. You recall at the last portfolio committee meeting, we did advise the committee on the revenue turnaround strategy for the PPRA, and this is one area where it has become the objective of the board to ensure that we do turn around in this area. And then section 54, subsection 6, Chairperson, again, it talks to just now the requirement by the property practitioners that they need to submit audit reports to us, and the due date is coming now, the end of August. And then we'll then be able to match what we're receiving from the practitioners versus what we have received from the banks. And then, Chair, we're mandated by the board to receive a legal opinion, relating to section 47, subsection 3, where the board was of the view that for all practitioners that are not compliant with our act, i.e. not submitting audit reports on time, it can be used, business as usual. We need to hold them accountable, to such an extent to even withdraw their FFCs. And this legal opinion was submitted and sent to the respective committee last week, Friday, Chairperson. So I'm sure when we come back next, we will be able to report on the remedies that we do have as the regulatory body. And then, Chair, similarly, this slide then talks to the oversight and compliance by the board as the accounting authority. And section 9, subsection G, this is the provision that requires the board to advise the minister on the efficacy of the PPA, the state of transformation of the industry, which is something that I believe we are doing well as an entity, even though there's still a long ways to go. The prescribing of regulations, the education and training of property practitioners, which I alluded to earlier, and any other matters on which the minister requires the advice of the board. And then, again, section 61 is stipulated, Chairperson. So here, and I will also allow through you, Chair, for the board chairperson to amplify on areas that I may have missed. But thus far, under this board, we have submitted a business case to the minister, just advising her on the revenue leakage that the entity has experienced as a result of the promulgation of the act. It is, I think it's a good act, but it is flawed, Chairperson. And that was submitted, I believe, in earlier this year. And then the regulation amendment process is underway, where we said we should look, the board is looking into which provisions will be able to reverse the revenue leakage as an interim measure. And once again, this process is underway with the Department of Human Settlements. I know it is headed by Ndate Masemola, who's in our midst today. And then the code of conduct was gazetted by the minister in February 22, shortly after the promulgation of the act. But Chair, the chairperson of the board can amplify as well on the oversight and compliance. And then through you, Chair, the next few slides talk about the going concern and the financial sustainability of the PPRA. So if I can hand over to the CFO, and then I will come and conclude.
Thank you, CE. Good day, Minister, DM, honorable members of the House, and thank you for the opportunity. I'll be taking the House through the financial sustainability of the PPRA, which consist of two subsidiary companies, which is the Fidelity Fund and the Transformation Fund. Chairperson, we closed the books with approximately 629 million odd in terms of the accumulated surplus. The group has maintained a surplus on 2 comparative years, and our net cash inflow has improved from 28 million to 72 million. Chairperson, revenue in terms of the property practitioners who pays their FFCs, who pays for their CPDs and examinations, also has improved by almost 5% to 96 million odd. Chairperson, also what has already been highlighted in the House, that we have a liquidity issue, but the contributing factor of the liquidity issue pertains to the deferred revenue. The FFCs, when they are dispatched, they are valid for the period of 3 years, so the subsequent 2 years is deferred. So by isolating the deferred revenue from the liquidity ratio, basically we are marginally in a good position. But based on the financial analysis and the principles, we had to incorporate the deferred revenue, Chairperson. But the majority of it, which is about 31 million odd, pertains to is sitting under payables, Chairperson. Then in terms of the solvency, is positive. Our total assets are exceeding our total liabilities, Chairperson, by approximately 66 million. Then, Chairperson, during the last board, the financial sustainability framework was introduced, focusing on 5 strategic pillars, which are pivotal for us to be sustainable in the future, Chairperson. I'll just maybe highlight 2 or 3 of which are of paramount importance, is the regulatory compliance. So we need to ensure that we enforce compliance to boost our revenue streams and collecting, so we will be able to collect what is due to us timelessly, Chairperson. That will boost our working capital. And also ICT infrastructure is one of also a focal area that we are automating all our processes to ensure that, I think the subsequent slide that the CE will come to, it will show that we have automated. Now the property practitioners are able to apply online to get their certificate or tool of trade, Chairperson. Then another item or a pillar that was also of importance was the revenue optimization. I think the current leakage coming from the legislation and the regulations, I think the CE have touched on it. What is pivotal now, our closing balance of the debtors book, Chair, are accurate, Chairperson. So we are developing a debtors collecting strategy, of which will introduce the debt collectors, of which they'll be able to enforce property practitioners to pay fines and penalties, because that's the majority of what is sitting in our debtors book, Chairperson. Then maybe the last pivotal pillar is also transformation and partnership. Chairperson, we are embarking on strategic partnering with the ITC, DBSA, PIC, and NYDA, not only for financial purposes, but also for transformational purposes, Chairperson. Chairperson, I've already mentioned that we need to accelerate our debtors collection, of which now we are comfortable and we've got assurance that our debtors book closing balances are accurate. Chairperson, as the CE already alluded, that we have onboarded the 12 sectors, Chairperson, and on a quarterly basis, we are analyzing and reporting on revenue performance and also introducing some remedial actions appropriately, Chairperson, in that sphere. Chairperson, the Fidelity Fund, it's also a going concern. The current ratios and the solvency ratios, the liquidity, they are positive, Chairperson, above the benchmarking. Chairperson, the Fidelity Fund, Chair, I think the total assets, this is where they are approximate close to 600 million odd, and there's a strategy, Chairperson, of the investment portfolio expert that will be appointed in the subsequent quarters to take money and try to invest it within the National Treasury framework to maximize our interest, so we can able to ring finance and support PPR in terms of the management fees, and also the transformation fund in terms of the support for the SMMEs. Chairperson, I won't reiterate on the ratios. So that's the current position and the future of the PPRA. Thank you, Chair.
Chairperson, I did, well, the CFO just alluded to the FFC MS, the Fidelity Fund Certificate Management System, that went live on the 12th of June. And in the month of, since this implementation, Chairperson and members, and I know this is one area where we had said that we will digitize, and the time has finally come. And in Q1, there were over 3,800 transactions that were processed, and 99.2% of those was all electronic. And currently on our portal, when we disseminated these slides, there were 701 practitioner portal users. So this is really a milestone that we've have achieved, and we're excited about as the entity. And then, Chair, on the right-hand side, the FFC management system is the one for obviously FFC registrations and applications. And then on the right-hand side, we've got the risk management system that we are also introducing to the entity, which will be a first again. And we are planning on going live in August of this year. This will improve, obviously, our compliance governance reporting that we do quarterly to the department, as well as the Audit and Risk Committee Chairperson. And here, Chair, we're just highlighting, what is it that we're also doing to strengthen our cybersecurity and digital resilience. You'd recall, I think it was early last year, April, where we had experienced a cyber threat at the entity. So we've really been deliberate on such to ensure that we don't have, it doesn't reoccur. And I must concede, in that business unit, we've really made a lot of strides. And Retabile, who's here, Chair, who is the acting chief Ombud, does sit on our ICT steering committee, Chair, and which is another area where, we've always been told that we are not collaborating as entities, we are working in silos. So we've taken that to heart, and it is currently being implemented where obviously they are giving advice on ICT, on the ICT environment of the organization, because as CSOS, that's one initiative that they've started a few years ago. So we are benchmarking with them, but also they are serving as an advisory capacity, if I can call it that. And that's our digital transformation journey, Chairperson and members, that, we are digitizing our services, given the financial constraints, so that we are able to improve efficiency and strengthen governance, and most importantly, steer public confidence. Chair, we were also asked to report on our stakeholder engagements, and I won't go through each and every one of them, Chair, but this is just to illustrate that we have been, engaging with stakeholders in person, digitally, on webinars, and we are not only staying in Sandton, we are going throughout the country. We've been to Limpopo several times, Soweto, Mpumalanga, and just wanted to reiterate once again, Chair, that this we are not doing just with the PPRA. We do collaborate with our sister entities as to share costs when we are engaging stakeholders, Chairperson. And then that will bring us to the end of our presentation, Chair. And we recommend that the Portfolio Committee notes the presentation. And I don't know if the Chair wanted to come in through you, Chair. Thanks.
Okay, Chair, before the Minister comes in.
Yes, thank you, Chairperson. I'll just, everything has been covered. I just wanted to highlight again on the issue of the business case that we have made to our Honorable Minister, our DM, had the opportunity to hear about it when she paid us a visit. And we'd still like to meet with our minister and make a clear presentation to her, much as we know that we are trying alternative means to be above the water. But we still believe that our parent department would still listen to us because the inefficiency of the IT system continue to hamstrung the financial capability of the PPRA. We really need to streamline it, even improve on the audit findings that are actually originated by an inefficient IT system. So we can find means and ways together with our department as to how to fast track curing those defects. We have already started, but the pace is not as it should have been. Thank you for the opportunity.
Thank you. Today is the 5th of August. Isn't it? Yeah. CEO, today is the 5th of August.
Hey, Chair, Honorable Pool is finished there, you know, for a lack of explaining it. Chair, I'm not sure if I now have your permission just to come through.
Yes, Minister.
Thank you very much, Chair. I just wanted to make comments on both CISOs and PPRA. But maybe start with PPRA because it has just landed on their presentation. Chair, I thought the first thing that both the Chair and the CEO will do, I didn't want to take the stage for them, will be to introduce the CFO. CFO is attending for the first time, but CFO, is it the second time? Oh, okay. You can hear there is a huge difference in the line and the shape of the finances and the clean. One of the measures, in fact, I think they are left with only one item that they couldn't finish in the audit action plan. Something, just one that stood between them and a qualified audit. After so many years. Now, last time when we engaged with you, we couldn't account for our data, our clearance book, and we are now so detailed, we know everything, which will capacitate two areas. The transformation area, which you can still see that it's stuck at the registration and the capacity programs that they are running to enhance previously disadvantaged individuals to get into the sector and get the sites that they are allocated that are profitable. You can see it's still stuck and predominantly white. Yes, sharing both white male and female, but the other PDIs are very low. But they are having programs now moving from one province to the other. The past was KZN, this time I think they're in Mpumalanga, and they're drawing other provinces in training and capacity, and that will enhance. The transformation, oh yes, that's the part that I've spoken to. But the last part, which covers both of them, Chair, which I think needs to be emphasized, is what are the lessons learned? You know, it's one thing for us to come here and say to honorable members, the entity is not financially stable, its liquidity ratio is poor. When an entity was once high and up and could afford everything, I think we need to draw lessons so that the future becomes even better as we are walking towards stabilization. And yes, Chair, this is historical, honorable members. It does not necessarily reside with the current chairperson or even the current CEOs. But the lessons we have learned was that even ourselves as a department became a bit lax in the increase of the payments, salaries, board sittings and everything. That's what depleted the funds in the main, in the two entities. And I thought both CFOs should lift that up because it's a lesson we've learned really in trying to rework back and how we can take ourselves into strength and then never to repeat. And I'm mentioning this because you honorable members are also in this term new. These issues are relatively historical. But it is important that every time we come here, you also keep a note on all that. But the department has put measures as well in terms of the monitoring of sittings, the remuneration and everything to make sure that there is stability. And not only in these two entities, there are other which you can still see they are still. And that is why CEO PPRA still talks about some of the issues which are historical that they have to deal with. You have got issues, for example, where ordinary, old executives in PPRA, their medical aids are 100% drawn from the entity. Things which does not happen even in the industry. Not even the rich man gives that to his or her employees. There's a portion that you pay, princess. There's a portion that the states pay. But it was just free for all. So that they need to deal with the difficult task of going back into engaging, because these were employment and contractual issues. But I think it is important because we shouldn't only target the softer issues in dealing with the historical. Otherwise, we may save it for a year or two. If we hand it over to somebody else, it's likely to collapse if the real reasoning of the issues are not being picked up. CISOs, Chair, the last part, the ICT and revenue management have been submitted, and we've had 2 sessions in the department in terms of trying to review at PPRA and assist them. So Chair is right, they are waiting for the department, but there are other areas as well which we also need to be convinced, because we cannot in any way take in the department funds that are meant for communities. We prioritize them to look into the ICT. Yes, it is critical, but we've been trying to find other ways on how we could try to strategize for them to attain that, because we believe each and every cent that is allocated for the end of the benefit of the community, particularly when we've put ourselves in this problem. The board needs to still sit down and see where else can it cut, even if it asks us to meet them halfway or somewhere to turn around. But we are at the table, Chair. We are engaging. And that is why I was saying to PPRA, they must go also take on the difficult tasks and challenges that makes them save money as we speak, for them to put into programs that can still yield more. So we will respond, and maybe the Chair must know that the response may not necessarily be what they are asking for. I've done the same. I've had the turnaround discussion with the NFHC, and their request was, Minister, if you give us about 300 million, we are good. I was like, go back. And the plan is good. CISOS is in the same position. I'm going to start engaging with them. The crux of the matter here is we need to tighten on the screws on also how are we spending. That is why I was saying CISOs can't say to me they want to CSI. It's good. It's good. It's good governance practice. But under the financial conditions that we are in, even 1%, as their policy suggests, is not something that I can approve, at least at this moment. Futuristically, maybe we can look into that. I like how the CFO of CISOs, which is the issue which we raised when we were in a discussion with CISOs as the shareholder. Chair, it is very difficult for CISOs to put a target on how are they going to increase registration of existing and new schemes. But to me, that is not acceptable. I raised it, and much as the presentation came, I am fine for now with that, but they need to commit. Increase on their stakeholder and marketing, and register existing and new, and they will increase on their levies or on their funds. That also include the rate and the ratio in which they've been charging, which has been constant or stagnant for quite a number of years. And I insist on this, Chair, because I do believe that in them dealing with key strategic stakeholders, for example, there's no estate which gets to be registered without it passing through a certain municipality. So CISOs needs to be able to say to all of us, hey, I'm going to cover 8 metros this year. It's a start. If the metro is too big, they can be able to say out of 8, we'll deal with 3. And we will clean all the old and all the new. Second, and these are government entities, it costs nothing. You go to a free boardroom, you engage the property and LED leaders in the municipalities. You get the information that you need. You go and juxtapose that information with the deeds office. Okay, are they done here? Is the property now registered? Is it applicable? You can also do that with SARS, which is a government entity. Is it now trading? Is it fully? You cannot just come and say, I'm going to increase, and you stay there. You don't even set a target. It's very comfortable for them to talk a little bit on the 2 or the whatever million that would have increased. The difficult task, Chair, we still face, that I admit, is that we still can't respond thoroughly to this question. We'll still go back to the drawing board. And really the nuts and bolts on how do we get into the financial sustainability. They did the same mistake as well. And I'm alive to the fact that it's not the current chair, it's not the current executives. They just paid themselves until they remained with nothing. So we also need to say, what are the stopgap measures that we'll put in terms of the regularization of ensuring that this is what is kept. Cabinet is assisting, National Treasury is trying to deal with all the baselines for the entities. Because it's not only common with us, it differs from one department, one entity to the other. We've also realized that it is a gap. But we don't necessarily have to wait for that process. I think we can be able to deal with it ourselves. I think those were the critical points. And I've covered the audit for PPRA. And it shows, Chair, that if we put our heads together and get the really qualified people who meet the requirements, who are bringing a skill, we do see a turnaround. And PPRA is on the right direction, but I think there are still some few difficult questions we need to push ourselves to respond to. Then I am certain that, Princess, next time, there must be an unqualified audit at this space as well. Thank you.
Thanks, Minister. When you have a CFO who's focused, don't make him or her act as an accounting officer because you are defocusing that. Thanks very much. Honorable Ruteva, I think today you learned peremptory means instructive. You had Advocate Basamolana. Peremptory. Okay, no, that's good. That's law 101. Okay, honorable members, those are the two presentations. Can we engage with them? Honorable Poole, followed by Honorable Gamede, Honorable Ditebe, Honorable Abada. You'll indicate to which organization, your entity, you are directing your question or comment.
Thank you, Chair. I will go straight to my 3 questions for CISOs and 3 questions for PRA. But allow me first, I want to know where is the personal bank of Minister? Personal bank, so that I can apply for my constituency for the historical flats to renovate it and remove the asbestos roofs on it. That's why I'm laughing. It seems you're a bank. But nevertheless...
But before you continue, can I check? Chair Sisos, where do you buy your suits nowadays? Are you still buying at Pick and Pay? CFO?
Chair, I have an account at Pick and Pay. So I still buy from Pick and Pay. Chair. Thank you so much.
Oh, even the new CFO of PPRA is better, still better than you.
Those they speak in billions. I'm still a treasurer.
All right.
Question one for CISO's chairperson. Nearly all CISO's revenue depends on levy collection, yet levy compliance remains below target. When enforcement measures will materially improve compliance, and by when does CISO's expect to achieve a financially sustainable collection rate? Question 2, while no new backlog has accumulated this year, over 4,800 historical disputes remain outstanding. What resources and management interventions are in place to ensure that this backlog is eliminated within the promised timeframe, and what risk could delay this target? Question 3, finally, CISOs acknowledges that it still does not have a complete national register of community schemes. How can the regulator effectively enforce compliance and protect consumers without a comprehensive database? And what milestones should Parliament use to monitor progress? For PRA, question 1, the authority itself recorded a deficit and remains dependent on management fees from the Property Practitioners Fidelity Fund. What is a long-term plan to reduce the dependence and ensure that the regulator can remain financially sustainable without relying so heavily on the fund income? The presentation shows growth in PDI registrations, yet white principals still significantly outnumber black principals. Beyond increasing registrations, what measurable interventions are producing sustainable ownership, businesses, growth, and retention of black-owned property enterprises? Question 3, the new Fidelity Fund's certificate management system had been presented as a major success. What measurable improvements has it delivered in reducing application turnaround times, complaint resolution, and backlogs? And how will the committee monitor whether these improvements are sustained over the next 12 months? Thank you, Chair.
Thank you. Honorable Gamede.
Thank you very much, Chairperson. Let me start with CISOs. The briefing exposes a significant structural paradox within the community scheme Ombud service. While the organization boasts a sophisticated governance architecture featuring 6 specialized oversight committees, it remains critically vulnerable at the executive level, operating with acting officials in the pivotal roles of the chief ombud and the chief financial officer. This lack of a permanent leadership is likely contributes to the stagnation of the universal scheme registration goal. The admission that a credible national register will not be fully implemented until March 2030, nearly 2 decades after the legislative mandate, suggests a systemic failure in data strategy. This delay fundamentally undermines the CISO's revenue model, as the organization cannot effectively collect levies or enforce compliance without first identifying the universe of schemes in it is meant to regulate. My question, Chairperson, given that the community scheme registration strategy and the compliance maturity model are projected for completion only by 2030, how does the board plan to mitigate the immediate financial risk posed by non-payment of levies and legacy data fragmentation in the interim? And what specific performance benchmarks are being used to hold the acting executive leadership accountable for these long-term backlogs? Let me quickly go to the PPRA. PPRA, we are so fortunate. We have got, I can see we have brought a defense army in the form of a minister. There is a shrinking inconsistency in the financial picture. Looking at slide 15 reports, a current ratio of 0.76 and a quick ratio of 0.76, both below the 2.1 benchmark for the year ended 31 March 2026, while slide 18 alone reports a current ratio of 15.63 for quarter 1 financial year 2026-2027 against an unaudited financial year 2025-2026 figure of 18.68, a more than 20-fold difference for essential adjacent reporting period. Left unreconciled, this undermines confidence in the going concern narrative the NEC is trying to build. My question, Chairperson, to PPRA, given that on slide 18 shows a negative 48% net surplus on turnover for quarter 1 financial year and 2026-2027 versus plus 14% of the prior year, and slide 19 attributes the projected recovery to high peak session of property practitioners fertility fund in quarter 2. What happens to the authorities going concern position if that seasonal revenue underperforms, particularly since slide 15 already flags heavy reliance on the PPFF, which is property practitioners fertility fund. Ngifunde manje ngayibambisisa. Management fee of 44% of revenue. Thank you very much, Chairperson. Thanks, Minister, for being the spokesperson. I've learned. Thank you, Chair.
You have 5 questions each. I don't know whether you want to deal with them or you have capacity to take more. You want to deal with them? Okay, let's deal with them.
Chair, I'm going to propose that we deal with the questions that we've already received, and I'm going to ask on the acting Chief Ombuds and acting CFO to respond. I'll then come in, Chair, if there's anything further that needs to be reinforced. Thank you, Chair.
Thank you very much. I think on the questions around backlog, what interventions are we putting in place and what risk could hinder the CISOs in achieving this? I think, Chair, it is important to note that, as per the presentation, we've indicated that this far, the CISOs has already made some strides in trying to clear the backlog. On the presentation, we indicated that as of December 2025, we had a backlog of 11,838. And as at June 30th, 2026, we had a backlog of 4,810. And I think we can clearly see, Chair, that the numbers are there, to tell us a story. As much we still have a backlog, but there is progress that has been made. Because what happens is that we are dealing with new matters at the same time dealing with the backlog. Meanwhile, we're also trying to address the issue of capacity in terms of part-time adjudicators. So the CISOs has gone out on an advert, a tender advert, to source more part-time adjudicators in order, to deal with the backlog. The risk would be, in fact, when you advertise, there's no guarantee that you will get reputable service providers. You can receive, let's say, 150 bids, only to find out out of that 150, you'll only get 20 that are able to, to make it through to the appointed panel, which, poses a risk on its own. But we are continually, making sure that we address this. But apart from that, to assist with the issue of the backlog, on the 1st of April 2026, we went officially live on the CISOS Connect dispute module, and we've been receiving positive feedback regarding that. The aim is to ensure that, in fact, we are envisaging that by the end of financial year, the backlog will be cleared, which is the 4,810 that I've referred to, Chairperson. In terms of registration targets, I think it is important, Chair, to understand the issue of registration by understanding the root causes, why the CISOs is struggling to, register. We're operating in a space where the CISOs does not have the powers to enforce, which I've touched that in my presentation. I spoke about Section 34 of the CISOS Act, which speaks to offenses and penalties. And I keep on referring to the receiver of revenue. All of us in this room, we are paying taxes. And if you happen to default, we know what will happen if you don't pay SARS. It's either SARS will come and attach your assets or something will happen. Either whether it takes time, but something will happen, which is the powers that the CISOS doesn't have. You get schemes that are intentionally not complying with the CSOs, because it's people who are understanding the gaps within the legal framework that CSOs is operating within. So it is important that, you know, we understand the underlying root causes. You know, as much as saying, yes, we are trying by all means to address registration targets. So in essence, Chair, the CSOs, you know, has put some strategies in place, you know, to address the registration targets. We set to achieve at least 20,000 schemes in terms of registration by 2030, meaning we'll be doing 4,000 a year. Currently, we are sitting at 38,000, around 38,000 in terms of schemes that are registered. And we envisage that in the country, there's approximately 70,000 schemes, meaning you minus 70,000, I mean 38,000 from 70,000, then that gives you the difference that, you know, what we still need to do, you know, as the CSOs. Part of the initiatives is to ensure that, you know, the Honorable Minister mentioned that, you know, we need to collaborate with our other government entities. So we're already in discussions with SARS to ensure that, you know, we pin down the schemes that are not complying. We also want to establish an MOU with CIPC, Deeds Office, all these government entities to ensure that there's more collaboration in order for us to reach these targets that have been set. I'm not sure if I've missed anything.
Thank you, Acting Chairwoman. I'm happy that you actually touched on the issue of SARS and the other state entities. But let me, Chair, talk to the issue of the financial sustainability in terms of our challenges that we're having. So we developed a revenue enhancement strategy, which looks at the period in which we could possibly turn around the situation that we're facing at CSOS. In my presentation, I covered the period of 18 to 24 months. That's the period that we're looking at turning around this financial situation. In that presentation, Chair, or even in our strategy, we've got key milestones that we'll be monitoring in terms of the progress if that strategy is actually working. What we have seen so far, as I reported, it's our one of the milestones is that we should be able to at least account for 85% revenue collection. We missed it by 3%, Chair. We accounted for 82% for this quarter. And then I think the committee will understand that this is the milestone that we are monitoring on a quarterly basis. In fact, Chair, we also have our internal, you know, at a lower level, that, you know, monitoring initiatives, that we are monitoring this target. The target of 4,000 schemes that we want to register in this year, it's monitored on a monthly basis in our EXCO and management committee meetings. So it's something that we have our eyes on, and then we report on, and we're happy, Chair, to report on this. The other issue that, Chair, I felt maybe I should also elaborate on, is on the issue of the backlog elimination, and I'm happy that the acting Chief Ombud has touched on it. What we have seen, even in our financials, that part of the part-time adjudicators has actually increased by over 60%. And then that means that we're actually paying more part-time adjudicators that are helping us to clear the backlog. We have appointed quite a number of part-time adjudicators, where we even went in to appoint part-time adjudicators that will actually assist in-house. So that's how intentional we are, Chair, as far as that is concerned. Now, on the question that was asked by Honorable Gamada, in terms of what we are actually doing, and then the acting chief Ombud has touched on how we can actually address this. So we have appointed services of debt collectors that go after these schemes that are refusing to pay. And I think in the last session, Honorable Member, we reported that some of these schemes, they even wanted to take us to court. They write to us letters to say, they go to their lawyers to say, stop following, our clients and. This is the resistance that we are getting from the industry. But we are not deterred by any means by such things. We actually increasing the services of the debt collectors to go after these schemes, to get the money that they should actually be paying. And hence, even in my presentation, Chair, I also indicated that we have a number of schemes that are actually entering into a payment arrangement as we find them. They are not able to pay us the money that they owe us since. So they enter into a payment arrangement that they can pay on an installment basis until they catch up. And such, we review that. We just don't accept what they put forward to us. We analyze their financials. We look at how capable they can be in order to settle their debt in a short space of time. I think those were the comments that relate to the finances. Thank you so much, Chair.
Thank you, Chair, through you. I'm just going to respond on one matter, Chair, and perhaps also reflect on my opening remarks to say that, one of the reasons why we have these sessions is for us to have these kinds of conversations where we are able to take from each other what we might not be thinking about ourselves, Chair. And having said that, I'm referring to what our Honorable Minister has said in terms of the strategy that we could take in addressing the issue of the non-registration of community schemes and the commitment that we as an organization need to make. To say, as an example, this year we're going to address so many metros and make sure that we exhaust those. And these are the kinds of ideas that we appreciate from these engagements. I mean, to the extent of that registration of community schemes, I even said the other day, the acting chief Ombud could attest to that. I said, it's enough that we look at the strategies from outside of who we are. But I do believe that sometimes we have to start in-house. And I made an example to say, some of the employees, or actually even most of the employees in that entity, stay within community schemes. Have we started with ourselves to say, each of us within the community schemes environment report where they stay, and have we checked that those community schemes are registered within our database? That's how basic some of these things can be done, and we do have that kind of an appreciation. But coming to responding to the question that was asked by Ntate Gamede around the issue of the vulnerability at the executive level position, I think in my opening remarks, I did say that one of the things that we as this board committed to was to bring stability to the entity, and in doing that is to bring stability at executive level, which I did say by the end of this week. The processes have happened, and by the end of this week we are going to submit to the minister our recommendations in as far as the results of that recruitment process has happened. I mean, as it is, the recruitment process for the chief Ombud and the chief financial officer have been finalized. So that those should take place in the very immediate future. Thank you, Chair.
Thank you. PPRA.
Thank you, Chair. I'll take the questions posed by Honorable Poole, and then the CFO will come in on the technical questions. The first question was around whether the FFC management system will be able to, will be able to process FFCs in a timely fashion. And then, Chair, we as an authority, we have a duty to give effect to our own regulations, right? And Section 49 stipulates the mandatory time period for issuing FFCs, which is 30 days. And we believe that this system will be able to do that because in the past, the reason why FFCs were not being issued on time is because people will submit non-compliant applications or incomplete application forms. So by virtue of this system, it will not allow you to submit the application form if it's not compliant. So that will self-fix, if I can put it that way. And then the second question through you, Chair, was around the PDI registrations, as I have factually reported through you, Chair, that the number of PDIs is not where we're supposed to be, and that's why this new pathway that we introduced 2 weeks ago is critical to address the very same question that Honorable Poole posed. Our regulation 33 provides that no person may act as a candidate property practitioner for more than 180 days in aggregate without the consent of the authority, after which the candidate is then required to sit for the PDE exam, which sits in our purview as a regulator, as a non-principal property practitioner. So what we are addressing here, Honorable Poole, through you, Chair, is exactly that, to ensure that, one, candidate property practitioners don't remain serial candidates, they become business owners, to address the numbers that we come to this forum to report on a quarterly basis, or the APP chairperson. So
GSA. So it affected the impairment loss, which touched your income statement. So it's not a permanent deficit. It was coming from the Auditors General findings. I just want to touch that. Then secondly, in terms of the financial sustainability, on a quarterly basis, we report to FinCom and the board on the actions that we perpetuate to improve our financial sustainability and maintain it on a continuous basis. And cost containment measures have been endorsed. In this coming financial year, Honorable Poole will be embarking on the strategy of compiling our own financial statements in-house. So there'll be a reduction of million odds on relying on the consultants to come and compile financial statements. Also, there's a data collection strategy that I've mentioned in our presentation, Chairperson, that now we are comfortable that we can chase these property practitioners that owes us. Closing balances are okay. We are charging penalties appropriately and the interest adequately so. So in this coming quarter, this new quarter will be able to have a dashboard showing which area of revenue stream we need to pursue to ensure that we push our revenue lines, Chairperson. Then also we have automated our data's age analysis as we are automating our workflows. So if you recall, Chairperson, previously our age analysis was manually intensive. So currently it's automated. We are able to charge interest and we are able to issue statements promptly, Chairperson, as an ongoing strategy. Last thing to mention, Chairperson, is that task force or task team that the CE and the Chairperson have already alluded to. It's going to pursue that age and interest that we charge on the trust accounts. So we also embarked and benchmarked with the LPC. Also, we had engagement with BASA. So we are on a right track, Chairperson, to ensure that we definitely, in this coming subsequent quarters, we can, on a monthly basis, invoice the property practitioners. I think the deficiency also, Chairperson, is on the property practitioners who don't submit audit reports. So there's a pool that will be able to curtail or to pursue. So we boost our revenue lines, Chairperson. So that's the revenue leakage that the monies are sitting there, and there is a strategy that has been endorsed by the board. Maybe coming to Honorable Gameda's query, Chairperson, slide 15 pertains to PPRA. Slide 18 is a validity fund. It's a subsidiary company. So they've been reported separately there. I just want to provide clarity in that. PPRA revenue streams are not identical to validity funds revenue streams. The 96.7 million that you referred to, it's for PPRA, the authority, which is the monies that we receive for the CPD, the exams, the penalties, and renewal of FFC. On the validity fund, the revenue streams are the new registration. When the property practitioner comes for the first time, the revenue goes to the validity fund, and the interest that we generate from the investment on the call accounts. So most of the bulk of the monies are sitting in our call accounts, which are called deposits. So it's part of the revenue streams that they sit under the validity fund. And also there's element of the agent interest that I've already spoken to, Chairperson. Chairperson, in terms of the analysis also coming from Honorable Kamede, the 48%, that ratio of net, the surplus, I think, Chairperson, it was just a seasonal issue where there was an accrual. PPFF pays PPFF pays the PPRA management fees. So there was an accrual of management fee. So it cost the income not to cover the operating expenses. So it's also not a sustainable negative, but it was just a cosmetic or just for this quarter under review, Chairperson. I just want to give clarity in that direction. Then, Chairperson, we are also embarking on restructuring the debtors department. Debtors department is core for us to able to have proper working capital and also improve our liquidity position, Chairperson. So we'll capacitate that department accordingly, Chairperson. I think I have covered the queries. Thank you, Chair.
Chairperson, are you fine?
Thank you, Chairperson. I'm fine. I just wanted to add that as the regulating authority, we deal with many stakeholders who are unduly benefiting from the current situation. And as and when we discover these unintended consequences of the new act, and we are seeking to redress that, because some of them, they don't really benefit the intended beneficiaries, like those disadvantaged communities. They threaten to take us to court, and they always do. Some of them, they are really litigious, because now what the CEO was presenting about the alternative accreditation system that we are seeking to fast track the entry level for the disadvantaged individuals. We are now receiving an influx of complaints now already from the current stakeholders who are benefiting from the one learner, one practitioner system. They don't want us to even think of an alternative, even though it's not serving our purpose 100%. We are saying we're not saying we're removing everything that's in place. We are saying we are introducing the new system that would facilitate entry and to benefit our what do we call them? The practitioners, yes, to benefit them meaningfully. So, and I know that once they start writing us letters, they'll be going to the minister and they'll be coming to the portfolio committee. So we are not going to be deterred from driving our transformation mandate because of that. We will listen to them, we will hear what they're saying, But if they choose to go to court, there isn't much we can do about it if they do not share our mission and our vision. I just wanted to caution.
Thank you, Chair. The last questions from Honorable Ditebe, followed by Honorable Abada.
Thank you very much, Chair. I'd like to concur with the Minister with regards to target setting by the different entities. In this instance, CSOS and PPRA, and in the context indeed of the doctrine of perpetual succession, I think it is proper that the current incumbents should not wash their hands of the responsibility that's been bestowed upon them merely on account of when they occupied office, but to look at this as a system, as an organization, as an institution that must be improved beyond what it was previously. So on that note, I'll agree with the Minister and say that the gauntlet that must be thrown both to the PPRA, CSOS, and indeed other entities of DHS is that they must seek to improve these institutions, these organizations beyond what they were when they first occupied office themselves. Having said that, Chair, I'd like to know what exact target has CSOS set itself, and we are very much appreciative of the target that they have achieved. So that particular pennant or milestone is important, even though there's a shortfall of three points to make it 85%. But in the context, again, of a learning organization, it is important to strive continually to improve, and I think they are set on that. So what is the exact strategy in terms of ensuring that the liquidity position of CSOS is not in doubt? At the moment, what will they say about the liquidity position? Is it minus less than 1.0 or more than that, greater than or less than? That is CSOS. And I think the same question goes to PPRA. If I'm not wrong, Chairperson, at one point when PPRA appeared before this committee, PPRA indicated that there was around 500 million rand, I may be wrong about the number, which potentially they could collect, but they are unable to do so due to a number of factors. And in the aftermath of that, and it's been some months since they last said that, when we met them on the other side of Parliament, have they taken any practical steps to ensure that they leverage that potential revenue which they could otherwise collect to make sure that they are self-sufficient? And when it comes to, let me, before I go to the PPRA with regards to a specific question, there are non-state actors, and this question is now to the CSOS. There are non-state actors such as your Development Action Group, which are involved in micro development, etc. And some of those might very well graduate into the sort of schemes that you are overseeing as CSOS. Are you liaising with such non-state actors, municipalities, etc.? And in some instances, municipalities themselves may be failing you because they will not be keeping a database of schemes that by law are supposed to be paying levies and you therefore exercising oversight. I heard you mention the absence or lack of enforcement. Are you not allowed to, perhaps within the context of alternative dispute resolution mechanisms, to do so, and if that fails, then to approach the High Court, after which that decision will be binding on the parties? I'm talking to CSOS now. To PPRA, you've made some strides with regards in particular to digital migration, etc. But are you certain, given the extent to which you are so heavily contested and litigated, that there could otherwise be other threats? And in this instance, I'm talking about malicious algorithms being directed at you. Are you sufficiently firewalled so that you do not face the sort of threat that you faced, CEO, as you've mentioned? Are you sufficiently firewalled, and do you have sufficient resources in place to ensure that you are sufficiently firewalled against botnets and whatever other such threats? We are talking artificial intelligence, and more often than not, we talk of it as if it's something, you know, that is always of benefit to everyone. But, you know, as I've said, there are malicious algorithms that can be deployed against organizations, and botnets being some of those. So are you therefore, in terms of human and material resources, sufficiently equipped and firewalled at a technical level so that you obviate such threats? I think, Chair, those are some of the issues. I cannot agree more with what the Minister said with regards to the PPRA setting its sights on a particular number of metros, because if you look at the very data that you have shared with us, the Stats SA, lots of data, and part of that will indicate that a great deal of our economic activity is driven in the metros. So it therefore makes sense that you should do so without suggesting that you should ignore secondary cities, for example. So, of course, this question would be relevant for both entities, CSOS and PPRA. Chairperson, those are my questions. Thank you very much.
Thank you. Maybe before Honorable Abada, the Minister wants to be released, or do you want her to come in?
No, Chair, I can keep to the portfolio. I'm number 16, so I'll join at the appropriate time. I'm debating at the NCOP, but I'm not lined up early.
Okay.
I am number 16, so I think we would have concluded by then, hopefully.
Yeah.
So Honorable Rabada can come.
Quickly, so that
Thank you, Chair. See, Minister has to hear what I have to say. Thank you, Minister. My questions are sort of covered. Thank you to both presentations, CSOS and PPRA. You know, whilst I accept the accountability from both entities, and I'm going to speak on both, and then I'll ask, I'll give my comments on each one individually. You know, and I know I sound like a broken record, and I say this all the time as well. You know, our people don't want to hear about the challenges we have. They just want to know that they're getting their houses, they're getting their title deeds, they're getting whatever it is that they require to have adequate homes with water and sanitation, with electricity, and whatever their needs are. So I understand the challenges, but we need to work harder and faster, and we need to try harder to ensure that our people get what they deserve. My comments to CSOS, so I don't have questions for both entities, but my comments to CSOS is, the presentation demonstrates that CSOS has become reactive rather than proactive, only responding decisively after governance failures, compliance gaps, and operational backlogs have accumulated over several years. While the turnaround strategy is ambitious, there is far greater emphasis on future plans than on accountability for past failures, leaving serious questions about governance and leadership unanswered. Effective regulation depends on credibility, persistent non-compliance, weak levy collection, and inherited backlogs undermine public confidence in CSOS's ability to fulfill its legislative mandate. My recommendations to CSOS, through you, Chair, I suggest quarterly progress reports with measurable targets, including reductions in the dispute backlog, increases in scheme registration, levy collection rates, and compliance levels, with clear reasons for any missed targets. CISO should submit a comprehensive consequence management report identifying officials or executive responsible for governance failures, delayed implementation, and operational shortcomings, together with disciplinary or corrective actions taken. And through you, Chair, again, I suggest we conduct regular oversight visits to verify that the turnaround strategy produces real improvements on the ground rather than relying solely on presentations and reported performance indicators. And our people, they're not interested in what we have to say on paper. They want to see things that are happening. And then to PPRA again, my questions are covered and you've covered a lot of them as well. So my comments again is, transformation cannot be measured by increased registration alone. It must be reflected in real ownership, leadership, and economic participation within the property sector. The authority appears to have recognized the industry's challenges, but recognition without decisive implementation and accountability does little to restore public confidence. Digital transformation is welcome, but technology cannot become a substitute for efficient governance, effective oversight, and quality service delivery. My recommendations, PPRA should submit quarterly reports with measurable transformation targets, including ownership, principal appointments, and retention of previously disadvantaged practitioners. The authority should provide the committee with a time-bound implementation plan to remove financial and regulatory barriers facing new entrants, including amendments to regulations and expanded funding mechanisms. And lastly, through you, Chair, the committee should strengthen oversight of the PPRA's operational backlogs, financial sustainability strategy, and ICT rollout to ensure that reported improvements result in faster, more accessible, and more accountable services for all South Africans. And at the end of the day, it's basically bringing back humanity and dignity to our people. Thank you, Chair.
Thank you. Lastly, Honorable.
Excuse me, Chair, I just meant to ask PPRA on the litigation against them by, I think it was Sakelicha or some other organization. What's the latest on that and what are the specific issues? Thank you.
CISOs.
Yeah, thanks, Chair. So, on the question that you ask, Honorable Chair, I'm going to be straightforward. And I think your analysis is actually correct. We're below the acceptable ratio of 1:1. However, there is an increase from last quarter that we reported. We were sitting at 0.8. We are sitting at 0.83. I must also indicate, Chair, that if you look at our, this is something that was also highlighted in our audit report, is the high debt ratio, meaning that we are taking longer to collect. And let me just quickly maybe explain that further. So, in the last quarter and the first quarter of this financial year, we've seen an increase in the billing, meaning that we're able to find these schemes, right, as part of our strategies that we are going to bill and collect from them. So that improvement will be translated into us being able to, rise above the acceptable level of that ratio that Honorable Ditebe mentioned. I think that was the question. Thank you so much, Chair.
Thank you.
Thank you, Chair. On the question of whether are we liaising with non-state actors,
Recording stopped.
why is this thing always happen only with me?
It's controlled somewhere, don't worry. Continue quickly.
Thank you, Chair. Really, Tebe, we are liaising with non-state actors, and one of them is the Bank Association of South Africa, where we share common clients, people who are buying in estates and etc.
Recording in progress.
The MOU is in advanced stages for us, to form that collaboration. So we're not only limiting the collaboration with SOEs or government entities. So we are looking into a broader perspective on how can we collaborate, because the industry is too big for us to confine ourselves only, with government entities. Yeah. Thank you, Chair.
Thank you, Chair. Chair, I think the colleagues have covered me on most, but we take note of the issues of comment that have been raised by members, honourable members. More so to the fact that what should be our legacy as this new board is to accept that we found the boards or these entities at a certain point, and ours is to say we need to see the improvement during our time. And I think that is a legacy that we all have a common understanding of as this current board, Chair. So we do take note of those. Thank you very much.
Thank you, Chair. PPRA? You want to come in before?
Thank you, Chair. Yes, we agree with the member. Indeed, we also need to deal with the issue of upskilling and encouraging the users of the ICT system that it does not replace their commitment and their efficacy in service delivery. They also have to be on their toes to make sure that it functions ceaselessly. With regards to the Sakeliga matter, we are still awaiting the judgment. However, we are apprehensive based on the fact that a similar case that was taken to court prior, the judgment has been given, and it's not, if the precedent will have to be followed, then the indications are not positive, but we'll just wait because each case is decided on its own merit. Thank you.
See?
Yes, thank you, Chair. The comments from Honorable Abada are noted, so we will submit that quarterly report then moving forward. And then the questions that Honorable Ditebe raised around malicious activities. Member, we have not received any or experienced any malicious activities since the launch of this app. We do run vulnerability tests on a regular basis, or every month rather. And we have actively ensured that our firewalls are blocking unauthorized network traffic as well. And we have also deployed endpoint protection with behavior monitoring that our the ICT department is doing. In terms of capacity, I think it's safe to say that we still don't have 100% capacity in that business unit, but this is the first year that AG was satisfied with the staff complement in that business unit, so they didn't raise it. So I think we are doing fine with what we have. And then, Chair, again, around the 15 million rand exercise, Honorable Ditebe, through you, Chair. The Chair earlier spoke about the task team that was developed. There are board members sitting on that task team. Subsequent to our meeting with the Portfolio Committee 2 months ago, we then engaged with the LPC, the Legal Practice Council. They flew from Cape Town to Gauteng, where we sat with them so that we can do a benchmarking exercise. And then subsequent to that, we went and met with the BASA, the Banking Association South Africa, because this is one initiative that we cannot single-handedly do as a PPRA. We have to involve the banks. And then the board rather mandated that we seek a legal opinion on the process that we had to undergo, which that legal opinion was also obtained, and we will be implementing the recommendations. And then we also gathered a cost associated with this exercise, because the banks will obviously have to integrate their systems to ensure that the practitioners, we automate the process. So that's what we're embarking upon, automation of the interest collection of trust accounts from practitioners. And then there's just an element of whether we need to amend our legislation, or can we do this through the regulation review process that we're embarking upon with the department, which we're doing that. So, Chair, it's safe to say that we have moved since the last time you saw us, but what the board was strict on was the implementation period, because it can't be we're going to implement in 3 years. They want to see immediate implementation of the process so that we are able to then see results, which is revenue for the authority. And then Chair did touch on the litigation issue, Honorable Ditebe, through you, Chair. So we're still waiting on Sakelicha as well as RCC matters. Thank you, Chair.
Thank you. DG?
Chair, thank you very much. Perhaps to aid the committee to also know the interventions on the side of the department in trying to support the entities, and which Minister has called for those interventions to be made to ensure the sustainability and efficacy of the entities. In the case of CISOs, we are undertaking a review, and legal services has started. They have done their first working paper on this matter. The issue here is the fact of our recognition that when the Amendment Act was done in this regard, it actually is relying on the goodwill of the schemes that they would come forward and register themselves. It doesn't make it compulsory at law to be registered. For instance, you would not practice as a doctor if you don't register with the Health Professions Council. The law is very clear. And if you practice, then you are violating the law. But the current law doesn't compel the schemes to register. It actually mandates them to run after them, identifying them, and at each identification, some argue that we are not a scheme as what the law say or whatever, and there's always contestations. We need to close that gap, and that can only be closed by a legislative review. And that first part we are busy with. It's on our roll of amendments to the laws that we want to bring before Parliament. You would recall, Chair, because of the PI thing, we have had to revise our role with the leader of government business. And we were told that we must do trade-offs. If we are fast-tracking the PI, then some of our legislation must take the back burner. And unfortunately, the CISOS amendment was one of those we had to do a trade-off to say which two must go down in favor of which two going ahead. And so we put the Human Settlements Bill ahead together with this. We still have other laws. You'll see our role has like 7 different pieces of things to deal with, including regulations to the new act President assented to, the Consumer Protection Act for the NHBRC. So we have our prioritization of that role. Unfortunately, like I'm saying, this took a bit of a back burner because of the prioritization of the PI Act. Now let me move to, so in essence, we will work with them to close this loophole in the ultimate, to be fully empowered. But so long we have agreed with them that they must be aggressive in their identification, billing, and also collection. Their biggest issue, as we see it, is that they take way too long to collect the money, and they seem to be shy to really enforce. So there must be a bit draconian in enforcing this thing with the debt collectors that they appoint. They've got to go full steam, and they need to set examples. And I think right now, the reason there is high compliance rates of submission and filing of your tax returns is because in the early years, SARS did the heavy lifting. They were a bit draconian. Right now, they don't even have to say anything. People comply because they know that they are going to come for you if you don't. And we are calling for CISOs to be in that mode and to know that it must be a bit more forceful and aggressive to collect. When it comes to PPRA, with PPRA, we think that the legislative review, this act is not long, we have reviewed it. If we had to go again on a review to give the board more powers to actually determine fees and to do all of this that they are being contested from time to time, it's a bit of an overkill. We think that we can do a regulatory review. And that part is what the CEO says we have also started with. We will revise the regulations. Minister will look at them, will bring them to Parliament. The idea is so that the regime of determination of how much a practitioner must pay is key, because that is what is at the heart of the contestation. But we think that when we do benchmarking with similar regulatory institutions, the fees here, what these people are paying, are quite minute. They are too little. We think that they ought to collect a bit more. But obviously, they need to justify the regulatory mechanisms that they are financing with what they are collecting. We know that when the matter goes to court, that will be the real test at court. For the court would say, how reasonable is it, these charges you want to, and what exactly are they financing? And so that entire value chain we have said must be mapped and costed. So a market study around the costing of that must be done so that we can arrive at that point. The last part about this thing is that we had asked them to develop a revenue enhancement strategy. But at the core of it lies what she's saying, what the CEO is saying. A benchmark, and the best way is the Legal Practice Council and the Fidelity Fund there, because they also run the Fidelity Fund. That one runs exceptionally well. And there's no reason why we shouldn't put similar mechanisms and regulations that the Legal Practice Council has put and simply copy what they have done and apply it here. So the MOU they are working on, everything, is a welcome thing for us because we are certain that this is the pathway we have agreed with them towards interim stabilization, but long-term, the framework for pricing is important. And so that we are beyond reproach. The market study is what will stand up in good cause when we are taken to court, because we can anticipate there are those who don't want a stronger PPRA for obvious reasons. They are anti-transformation. They don't want a strong regulator who can actually change the picture you saw on the screen of what the color bar looks like in terms of the number of practitioners. So that's what we are driving, Chairperson, from our side as the department to support the entities. Thanks.
Thanks very much. Before I call on the Minister to do her closing remarks, can I suggest, honorable members, that we, what do you call that? We don't entertain minutes. We transfer that to Friday's meeting. Will that be fine? Seconded. Okay. Now, I sometimes watch on TV people selling houses in Cape Town, for example. Some houses going, or property, let me say property, going as far as 300 million, 200 million. So if I'm a, what, practitioner, I get commission, which is how much? 10%. How much?
Those fees, Chair, they're not legislated, right? But the norm is, the higher the property value, the commission is low, but 5% is the average.
Okay. So if I get 5% of that 200 million, it's about 10 million once. And I've seen your statistics, they're still dominated by whites. So if we are, I like the term used by the DG, if we are, you're trying to say we must be radical, but you used another term. Yeah, if we are draconian with our transformation, a lot of our people can benefit. A lot of our people can benefit because it creates jobs, but at the same time, it makes our people to make a bit of money out of that. Because if you are able to sell 4 properties a year at that amount, there's no way you can't be able to put bread on the table for your kids. Minister?
Thank you very much, Honorable Chair. I think DG did cover and chairpersons in response to quite honorable members. I just wanted to put one thing on record, Chair. DG touched on it a bit in terms of the review of the legislation for CISUs. That process that our legal services has started as well. It will assist, it will lift quite a great deal on what we would want to achieve. And I wouldn't elaborate more further, but it deals into the issues of whether it's an amendment or a regulation, and if it is, and how do we touch on it, and it should be able to lift. What I think we should emphasize to one another, not to engage ourselves into, and I think that's why the DG is even going to an extent of using words draconian, right? Is it can't take us too long as a state to visit another state entity, and we come and have an explanation that we still want to, as if we're talking about somewhere where we just can't pick up a phone and go next door, walk into their boardroom and be able to start engaging. And I think that was the spirit in which I was raising the issues of really putting ourselves and aligning ourselves as the entities and the department into targets that should assist us to stabilize at both CISOs and PPRA. Chair, what you are raising in this example of 200, 300 million talks to the transformation figures in relation to the registration. And I thought that CEO will talk at least to the programs that they are running already, which one tends to identify, capacitate the practitioners, but also in terms of, it's not every space, even the Africans who you find, you get them to be assigned to sell or to selling houses in Khayelitsha. Not that it is wrong, but it is not profitable. We need to have a scale that is equitable. The type of a house we are talking about, you will find it in Combs Bay or Sea Point or wherever. So you need a mix which is deliberate and intentional, where you are doing the demarcation also of those who you have capacitated, so that you can be able to say you are transforming the industry, but you are opening up for opportunities for PDIs, previously disadvantaged property practitioners. DM Chair is officially delegated, formally so, approved by the President to PPRA and CISOs. So when DM is at PPRA, she's not visiting. And there will not be a visit to PPRA, then a ministerial visit. Then it means I haven't delegated. But DM deals closely with the entities, go frequently to them to make sure that they are being assisted and the ministry is present in all the entities. We are not at the level where our deputy minister doesn't know what she wakes up and do. No, 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 no. We're not there, Chair. So, Chairperson, Kungubel, DM is not visiting. DM is performing full oversight over PPRA, and it's one of her many responsibilities in the department. I think she visits CISOs as well as part of her delegations. And she visits Western Cape, Eastern Cape, KwaZulu Natal, and whatever as part of her delegations. Northern Cape, we share the provinces as well, and who touches where and where. And it does not mean that I can't work here in the Western Cape or she can't work in other provinces. We assist one another. But at least she specifically focuses on murder eradication, on asbestos, or any other thing that relates to a particular province, so that we can jointly be able to cover and come and be responsive to you in the portfolio. Chair, let me thank you for the opportunity, really, for engaging with our team, and hopefully that we will come and put a convincing case in relation to blocked projects from SHRA. I will not want to dictate to how a portfolio manages and oversee us, but I of a view and a request that we will provide the report, Chair, fully to you in no more than 14 days on what we believe should be the framework on how we bring SHA on board and make sure that we do what we owe to the citizens as informed by our mandate, which is constitutional. I respect that, and I know that you also do, and we should be able to bring the social housing element up at the table as you have engaged with the two entities. Thank you very much, Chair, and thank you very much, honorable members, for the lessons of this day. Thank you.
Sorry, I'm like, you see, Minister, in the last meeting, when entities were presenting, the CFO of CISOs said, Chairperson, I'm not at that stage where I can go and buy my suit at Woolworths. I'm still buying at Pick and Pay. These other entities are already there. So, but today he has reported improvements. We think he's gradually getting out of Pick and Pay into Woolworths. I was saying we'll request your PLOs because they are sitting in our management committee meetings. And usually we finalize our programs there because we don't want a program where it gives you pressure. They know your schedules, they know your programs, and when we finalize our programs, they must be able to advise us so that when we deal with issues, we don't rush and compromise other engagements that you need to have, because when we do oversight, we'll need to discuss things in details to the satisfaction of members, not to rush. So we'll request that if you encourage them, always when we have our management meetings, they are able to attend to be able to input. We promise that we'll get an invite for next week, Friday, the 14th, on the launch. So it means, honorable members, in principle, we can agree that we might have to postpone that meeting, because when we have a meeting, they must be there in our meeting. Now, if they have this program, their launch, it means the department will not be there. Even if we are not necessarily discussing issues that affect the national department per se, but the national department must always be there. But the secretary will guide us once we have received an invite and see how the secretary will communicate to you and see how we do these things.
If we have a meeting, they're supposed to be here, and if they have got a lunch, we're supposed to be there.
Yeah, because the launch is in Gauteng. The launch is in Gauteng. Yeah. I think according to our program, we'll have our last physical engagement next week, which will be our last until we go to elections. Other engagements will be virtual until we come back from elections. So next week, because we're meeting the other 3 entities, I think it will be our last physical meeting. And there's a reason, I may not disclose it, there's a reason why we want entities to be here physical. Not you. We are left with HDA, NHBRC, and NHFC. And I'm reminded that the NHBRC regulations, Minister DG, I'm not sure whether they are done, the NHBRC regulations. So my appeal would be entities, leadership of entities, let's support one another. Let's work together. I think I got it from the minister that she's ready to support you. But this smaller things, remember, Minister, we're getting emails, phone calls now and then. Unions, from the leadership of the unions, members of the unions saying this and that. And once I was once an employee, I was once a leader of the union. Once I see that you are divided as a board or as management, I'll be able to take advantage of that. So it's important that chairpersons and board members support CEOs. CEOs also respect the authority of chairpersons and board members. And we make sure that we work together, support one another to take the process forward. Because if we don't work together, it will not be in our interest. We will all lose, but the public out there will look at us. So we're calling for your maximum support of each other, so that even when the minister comes to support you, you are able to get that. From the discussions, I take, I might be wrong, but there might be a need for organizational review, so that you complained about financial capacity and other things, because life is moving, it's not static. So we might need to consider that. But otherwise, to an extent, I think, speaking on behalf of the committee, we're happy with the progress made as reported today, and let's build on that progress so that we move forward. The department today got, although we're still waiting for an official report from the AG, but the department today reported that they got a clean audit. CISOs unqualified, possibly with matters. PPRA qualified, but is an improved qualification, I'm told. So gradually, we are getting there. So let's continue with that spirit and make sure that we work together. DD Ngongo, be on their case, so that you are able to be the eyes and ears of the DG and the minister, and we are able to intervene quickly where there are challenges, so that we don't wait until things are. So I'm just appealing for that. We get reports a lot about your internal rumblings, and we'll be happy if those can be addressed, because you are there to serve the people, and let's continue serving the people. Having said that, Do we have lunch? No lunch? Oh, okay. I'm sorry. I'm sorry for that. I'm not in control of the finances. He's in control of the finances. He decides whether to give us lunch or not. But he could have brought us that bread of Pick and Pay.
Honorable Chair, you are at the Pick and Pay level.
No, thanks very much. Thanks for coming. Thanks very much, honorable members. The meeting stand adjourned. Thanks. I know the chairperson of CISOs came in this morning at 3. She didn't sleep.